like to tender my apology for mentioning, but I'm mentioning this on emergency, Lordship. Lordship, on the last day of when the mentioning days fixed, Lordship has taken this mentioning, and on the open court, Lordship allowed the mentioning. But later I checked with the department. They said I think the mentioning has not been allowed. So I'm mentioning 1 second.
Been allowed. I've considered the urgency.
No, Lordship. On the last occasion when the order was passed, Lordship itself, himself was satisfied with the ground that there is a urgency, Lordship. Stay has not been granted to us. We have been.
Yes, please mention on the next day. Yes.
Lordship, my
please
date before the trial court is before the next date of mentioning.
All right. Nothing will happen. Please hand over the slip, non-prosecution.
Lordship.
Out of compelling circumstance, I'm mentioning item number 23 of Lordship's list, my lord.
Yes.
Difficulties this matter arising out of a Guardians and Wards Act matter. And the Guardians and Wards Act,
Yes.
where the learned district judge has passed an ex parte order directing the police to hand over the child tomorrow. And thereafter, the police has yesterday night at 10 p.m. arrived my home, directed me to hand over the documents. I was a mother and child. I say that I will visit.
Please wait. If it is not reached before 1:15, please mention.
May I have your lordship kind leave, my lord, to file, my lord, this revisional application without the certified copy.
Yes. What is the urgency?
My lord, urgency, my lord, the court, my lord, is hearing out, my lord, the injunction application without hearing my amendment application. My lord, the court has allowed the addition of party, but my lord, my amendment application has not.
All right. Leave to file with the
Lordship.
Sir, please don't mention. I have heard you. You have mentioned. Yes.
Permit to mention one matter for inclusion. It's a contempt.
Please come on next Wednesday. Please call the list.
Lordship. My interim order will be expiring in this end of June. Kindly.
Under compelling circumstances, I'm mentioning this matter. Tuesday is the next date fixed in the law learned courts.
Why did you not mention on last Wednesday?
Lordship, I have mentioned, but it is.
Then please don't mention again.
Lordship, for
Please
7
don't
years you are
mention.
not getting maintenance.
All right. Yes. Call the list.
My interim order is expiring on 30th of June.
Yes. Hand over the slip.
Hello, it's a contempt application.
Please mention on Wednesday.
Mr. Dipanjan Doctor.
Number one.
Lordship, Mr. Doctor is here. That matter.
Oh yes.
With regard to this. Item number
284 of today's list.
Item number 284. Yes. That is, please hand over the slip. That is the child's.
Yes.
Transfer.
Yes. Item number 1. Who is appearing?
Yes. Actually, it was kept with regard to that transfer thing. But you will kindly come to the Commercial Court Act 1.
Find the copy of the notification.
No, I'll tell you, Lordship. I could not get the copy because I sent it for the Commercial Court Department. They said it's an old notification. I don't have it right now. I have to search for it. But what I could gather, Lordship, kindly have a look at the Commercial Courts Act once.
Can you file it?
I asked him also. It's a central government notification. Yes, I told him also.
This honorable court had passed that
judgment that I have.
Dated 13th of October 2023, but nothing has been mentioned. It is just about identification of cases and transferring it to the concerned commercial court according to the pecuniary.
No, I'm not that notification.
Where is the notification?
That is the directions which have been passed by this honorable. That is as late.
But there is no notification according to you.
Yes. It is there. I thought that they.
No, it is not that notification.
Within 1 minute,
I'm keeping it on Monday.
Lordship, will hear me.
I will supply this notification to my lord within 10 minutes. Just get a printer. I was under the wrong impression that my learned friend will bring it.
No, Lordship will give me 1 minute. It is not this. It is not
keeping it on Monday.
It is not this notification. Lordship will hear me because Lordship will take up the.
Let Mrs.
No, Lordship will hear me. I have the notification. It's a 2016 notification. It's nothing concerned to this 23. Lordship will take the Commercial Courts Act once, section 15 once.
Commercial Courts Act.
has provided for a mechanism by which a suit shall be governed. I'm not going into those mechanisms again. Paragraph 18 is specified value. Now, Lordship will turn over the pages. Lordship will kindly come to paragraph 24.
Yes.
Even after constitution of a commercial court for the district of such and such, commercial disputes under the specified value was adjudicated by the court below, which is of without jurisdiction. The dispute between the parties fall under 210 of the commercial disputes. In the factual matrix, the suit was not transferred. None of the parties approached the civil court, though plea was not taken. But the court lacks inherent jurisdiction, yet we find there is no fetter on the appellant to have taken such a plea. Since the suit provides commercial dispute within the means, it is to be tried in commercial court. The defect of jurisdiction strikes at the authority of the court to pass such an order. So in 2017, which the learned Barashat court had passed an order that vacating the interim order, that is also bad. That is also bad. That is also without
That
jurisdiction.
vacating was in 2017.
2017. That is also bad, because this came into in 2016 and 2016 notification, and this should have been transferred immediately that point of time. This is an answer to my learned senior friend's question of my I'll say, let me complete. This is in answer to my learned senior friend's question of saying that I did not take appropriate steps. That order is also bad. Transfer is possible under the Act. I did not cite a notification also. The commercial courts was established in 2016, notification provided. This judgment provides that these subsequent orders are also bad.
All right. Yes, yes, Mr. Trivedi.
One. Dear Miller, if the court did not have jurisdiction, what was happening? The interim order was to be extended. So it was basically not extended. Nothing was dismissed. Interim order was vacated because it was an order of temporary eviction nature with needed extension. No application was filed. The court could not suo motu extend it. So therefore, if this analogy is taken of paragraph 24, then also the court was justified. If it does not have jurisdiction suo motu, how can a court extend an interim order where an application for extension of interim order is required? I'm asking a question to myself. So how is my learned friend is benefited?
2018 show cause orders were issued, show cause notices. Those are all bad.
It was dismissed by a commercial court. Now you should come to that. So
yes, absolutely.
24 does not come to his rescue.
So that is fine. That is fine.
Extension of interim order cannot be done suo motu. So even on being on the same page as he is, the court was without jurisdiction, show cause already gone. But the suit was dismissed by commercial court. So this particular judgment does not come to his rescue.
I bow down what he says. So his commercial
let my commercial come up with that notification which says specifically either in the Act or in the notification that notice is to be given.
I did not. The Act says so. The Act says so.
My lord, the other deviated. I am not wanting to join issue and amplify my argument, which has already been put rest by your lordship.
Yes, yes.
Lordship, if he can give a notification which specifies that the notice is to be given, he has a good case. And if I can show by 2023 notification, which is the latest, which does not say anything, the rule notification.
Where is that notification?
Within,
All right, this
within 10
supply.
minutes,
All right.
my lord, court officer will have it. I'll get a.
All right.
23 notifications of a different issue
But the
itself.
learned advocate
My lord, your lordship appeared in this matter in the year 2020, 2018, my lord, with Chandra, my lord, your lordship appeared.
I'm not inclined to take up this matter.
This matter is appearing for extension of interim order.
Yes.
My lord, I made, my lord, a blunder. My lord, I owe an apology to your lordship. My lord, neither, my lord, I served. No. Oh, my lord, I'm so. Yes, my lord, I have confessed that. I have confessed that. My lord, it just escaped, my lord, my learned advocate on records, my lord, mind. Just escaped.
You serve a copy?
Yes.
May I indicate one thing, Lord, if he's by the order impugned, Lord, his cross-examination has been closed. Lord, my lord will find.
No, no.
Take a copy. I'm not passing any orders today.
My lord, my examination in chief, my lord, was closed. My lord, I am PW1.
Already
My lord,
serving
may I
a
just
copy.
indicate one thing? My lord, I was PW1 in a probate matter. My lord, by delaying the matter, I am not going to be benefited. It's my father's will. My lord, I am the son, I am the executor, I have put the will, my lord, for probate. My lord was pleased, my lord, to stay, my lord, all further proceedings in the meantime. My lord, which does not otherwise inure to my benefit. But if in the meantime, my lord, this interim order is not extended,
I'm keeping it. Please serve him a copy.
I am immediately
Because,
serving him a copy.
Mr. Banerjee, this has expired in the month.
That's true. That's
So it
true.
has also expired.
Lord,
Serve him a copy. I'm keeping it. When do you want?
Monday, Lord.
So grateful to you. Lord. আমি আমারটা দিয়ে দিই
Banerjee learned at next.
Number 4.
So this is my affidavit of service.
Yes.
Interim order expired was till the end of May, Lordship. I mentioned it before expiry.
Or I'm extending it. Yes.
So item 5, I appeal to the petitioner, your lordship. This is appearing for orders.
Where is Mr. Ghosh?
Lordship, Mr. Ghosh is on his legs.
Where is the opposite party?
Lordship, they had appeared on the last occasion. Mr.
Yes,
Guddu
yes,
Singh
they
is
appeared.
appearing. Yes, your lordship.
Passed
Lordship,
over.
although my learned on record has not been able to inspect the report, but your lordship has said that the records have been traced in the court below. Lordship may
That is the report. Have you
Lord-
not seen the report of the district judge?
no, your lordship, my learned on record could not.
Why?
inspection
The
of
last occasion I asked
Yes,
you
your
to go
lordship.
through this. Please go through this report. Pass over. Yes, call the next matter.
Item number 6.
But I am for the petition. My lord. This is an application for expedition hearing of the suit, my lord, suit filed in the year 2007, my lord, for a specific performance of contract, my lord.
What is the
Not-
stage of the suit?
My lord, two application is now pending. One is for full shelf and another for local inspection, my lord. Examination of PW1 and PW2 and also DW was completed in the year 2008, my lord.
Who is your counterpart in the learned trial judge? What is the name of the learned advocate?
My lord. I don't know my lord, the name.
Passing it over or not today, please take instructions whether I can take up this matter or not.
Yes, yes.
এটা বোধহয় আগেরটা।
Item number 7. So the plaintiff, my lord, is the petitioner which your lordship, my lord, on the last occasion, your lordship
Lord, I'm for the
directed me to
opposite party.
serve. Lord, I have served.
My lord, I've been served a copy. My lord, I'm just praying for a day's accommodation as we are being led by
Why?
Mr. Rajmohan Chottoraj. He's not well. He informed me today morning. Matter can be taken on Monday, my
But
lord.
again, I don't have any problem with this if he's in difficulty. The only difficulty is not the matter goes down. The issue is very limited, my lord. The issue is with respect to, my lord, section 340, whether an application is required to be registered under a separate miscase under the civil rules and orders.
What has been provided in the civil rules and orders?
In the civil rules and orders, my lord, the old code, 1878 code has been
Mr.
referred.
Bhatti, this
Yeah,
has-
My lord, my only difficulty.
Personal
Yes.
difficulty.
My lord, keeps it as 4 orders, my lord. My lord, it
I'm not-
goes down, my lord, your
Yes,
lordship
yes,
knows, I
will
would
not
be
go
able
down.
to.
Yes, yes, call the next matter.
Item number 8.
No
Lord, may I
problem.
file the affidavit service?
No, I'm made not today only, otherwise an order is to be
In the
recorded.
meantime,
That will
I'll,
help you, Mr. Kolmokar, filing affidavit of service.
But some way, my lord,
It will
matter
help you.
goes down the list, my lord.
my lord, I filed the Vakalatnama in the department.
Yes, Mr. Nag.
My lord, may it please your lordship, the opposite party on KVL.
I have served.
Yes.
Now, my lord, the issue is very short, my lord. My lord, eviction order was passed. After the eviction order was passed, this is a public premises, my lord. After the eviction order is passed, my lord, they filed an appeal under section 9. Now, my lord, when they filed the appeal under section 9, they did not, my lord, no stay application was filed. And my lord, we took possession of the property.
You took possession.
I took possession of the property. And thereafter the matter came, they filed the stay application thereafter, and my lord, matter was taken up. My lord, when the matter was taken up, we specifically took the point that see, we have taken possession of the property. Now you cannot pass an order of stay because I have taken possession. So if you pass an order, you have to comply with section 9(3), that is the precondition. My lord, what happened? My lord, now my lord, kindly look at the impugned order.
Yes, what is 9(3)?
9(3)
premises
is
act.
my lord, the appeal and the precondition.
Public premises.
Lordship sees and no, my lord, 9(3).
ছিল তো একটা দেখে নি।
Where an appeal is preferred from the order of estate officer, the appellate officer may stay the enforcement of the order of such period and on such condition as he deems fit. So my submission is this and this is disjunctive. That has to be, there has to be a condition. And my lord, if lordship takes that,
This condition has been passed.
no condition, my lord, that is the issue. My lord, that is the issue here. My lord, the condition is passed on, my lord, on the old rate of rent.
That is the difference.
That is the issue, my lord. My lord, that's why I will be relying on Atmanam's case.
Mr. Nag, according to you, you have taken possession. If that is so, you are not entitled to any occupation charges.
Lordship, but I cannot utilize, my lord, lordship, my lord.
If it is your case that you
my
have
lord,
taken possession,
my lord, I appreciate that, but yeah, the operation of the
be happy with the amount which you have got.
lordship, me, I'm not today, my lord, as of,
If it is your case, you have taken
my lord,
possession.
the annual rent is, my lord, 18 lakhs.
Mr. Nag, if you have taken possession, nothing remains to be executed. The basic logic behind fixation of occupation charges is that the decree holder is being prevented from enjoying the fruits of the decree due to the passing of an
My
order.
lord, that,
So here you are not
But-
prevented according to your own.
now, my lord, if lordship will modify the order, I can utilize the, I don't have any problem, I will not face.
Not a question of modification. According to you, you are submitting that you are in possession. If you say so, how can you pay for increase of occupation charge?
My lord,
Please satisfy me on that.
my lord,
Occupation charges, Mr. Nag, you can bring Attaram. You can bring the series of judgments. All proceeds on the basis that the occupation charges is fixed in order to compensate the decree holder because he is
absolutely.
prevented from enjoying the fruits of the decree.
Preventing, my lord,
Yes,
that's
now,
the order.
Mr. Nag, your submission is that you have executed, you
My
have
lord,
taken
my
possession.
lord,
What further remains to be executed?
I-
Now,
Mm.
if your submission is accepted, if Mr. Kaur succeeds in the appeal, he can pray for restoration of possession, accepting your submission.
Lordship, now, my lord, now due to the stay of, my lord, lordship, what has fallen from your lordship, I am just repeating that. Due to the stay of order, my lord, I cannot enjoy the fruit of the possession of my property.
File an appropriate application for that the court will consider. Not in this.
My lord, kindly have a,
Here, or if you say that you have taken possession, I will record that and I will modify that portion that they are not required to pay occupation charges since you are claiming to be in possession.
my lord, kindly have a look just for a minute for the interim order. There are two issues. My lord, when I
Now,
say,
if you say that you are in possession, you are entitled to use that in your own way, I will give you liberty to file an application before the appellate.
lordship gives that, I am satisfied with
Yes,
it.
Mr. Kaur.
I am satisfied with that. Or else, my lord, he has to pay occupational charges.
Yes, see, I can't argue that here. Under the Public Premises Unauthorized Occupants Eviction Act, there is a procedure prescribed for taking possession. And Lord, I got 15 days time for the purpose of complying with the decree. I filed the appeal within 12 days because that's the statutory time under Section 9 to file the appeal. Exactly 12 days, appeal was filed. Now, Lord, the order of the estate officer says that after 15 days, if they don't get possession, they have to file a report to the estate officer. And then, Lord, the execution of the decree is in terms of Rule 7. Your Lordships may kindly take Public Premises Unauthorized Occupants Eviction Rules. Rule 7.
Rule 7.
Yes.
Yes.
So, Lord, if I obstruct, I am in possession. So, Lord, obviously, when he comes to take possession, I will obstruct because I have already filed an appeal.
But
Nobody-
maybe voluntarily you have given possession, Mr. Kaur.
Lord,
You are a law abiding.
my stand is I have not given possession. Your Lordship will find.
Mr. Kaur, I am not on that. He says he has taken possession.
Right.
Let
So,
him.
Lord, in so far as the possession issue is concerned, kindly, Lord, leave it for the appellate court.
Yes, I am not deciding. I will only record his submission
Correct.
that
And
he has taken possession.
I
And
deny.
I will record that you are disputing.
I am disputing and I'm
And-
paying the occupation charges because I am in possession.
And my lord, no, my lord, my lord, liberty may be granted, my lord, to you before approach.
File an appropriate application.
My lord, kindly grant me the liberty, or my lord, it will go on again, my lord. I have in possession without there being any
Or
purpose.
Mr. Nag,
Lordship.
your anxiety on the last occasion you said I can direct the appeal to be disposed of within a certain time.
Lordship, do that.
And
do
the
that, my
appellate
lord.
court would
Because my lord, I take.
Because now, Mr. Court, the Supreme Court decision as well as the statute requires a particular time.
Lordship.
Lord, I
So-
have no objection.
The appeal is otherwise ready.
Appeal
Any
is
other
ready.
interlocutory applications pending?
No, except stay there is that we will.
Disposed of.
They
It
have
is pending.
no,
It's
no.
been the- my lordship, the order is lordship sees, my lord.
It is otherwise ready for hearing.
Correct.
My lordship.
So I am directing to dispose of in the light of the observations. Where is that order?
My lord, I will supply today only. Today only, I will supply that. I will today only, I will supply.
Lord, the appeal can be disposed of within a limited period, whatever your Lordship directs. Kindly, my Lord, keep this issue open for the learned trial court, appellate court to decide.
Which
Whether,
issue?
whether, my Lord, possession was at all taken.
Mr. Kaur, now if Mr. Nag is not saying that, if he says, then another round of litigation, these interlocutory applications will go on for a sufficient period. That's after all,
No, because-
Mr. Nag to take a decision. If he says, yes, he wants to file interlocutory applications, the appeal court, then the appeal cannot be
No,
decided.
then it's
Or in the other way, I can direct only the hearing of the expedited.
My lord, kindly.
That's for you to
expedite the
decide.
hearing of the matter.
absolutely.
Mr. Nag, you have two options. It's for you to decide.
My lord, I tell, my lord, there are, my lord, I am agreeable to that. My lord, lordship sees the impugned order. My lord, when the question raised, my lord, the appeal court's order is, lordship says, I am not inclined to go into any discussion at this stage regarding possession of the suit property. Well, the order is completely without there being any application of mine. Considering the facts of that, it is still in the possession of the first
Nath, I will record that you have said that you are in possession. Nothing remains to be decided.
lordship, because my anxiety is total 37 crore is due. And the
Sir, Nath, there are two ways. If you want, I will give you liberty to file an interrogatory applications. You can fight it out on that. Or if you want, I can expedite because if I give you liberty to file an interrogatory application, I cannot direct the appeal to be disposed of within a specified
Can I
time.
come back on Monday?
Why?
But I have to take instruction from it. I cannot, statutory authority. I just
Clearly says that taking note of the fact that I am in possession, the order is passed. But Lord, if he wants this issue to be
Then,
decided.
Mr. Nag, I'm doing one thing. I'm giving you liberty to file an interrogatory applications late.
for the enhancement, for the changing the condition of the lordship.
That is already there.
That he can always apply.
No,
Lord,
no,
he can-
without this dispute, if Mr. Court says that he is in position, then he is due to pay on the scale of it.
Let's see, you apply.
No, that is the law.
That is not the ground on which this
That
227.
are you admitting Mr. Kaur is in possession?
No, I am not.
Then,
I am not.
Mr. Nag, it's your revision application. You are praying for enhancement of
Lordship.
and your submission is that you have taken possession. These two things cannot
Well,
go together.
I come back on Monday. Statutory authority, I cannot give any. Come. Kindly, I am in a situation.
All right, I will protect both your interests. Mr. Nag, priority will be on those days matters. That's the system which I'm. Yes. You have seen a passport. Where is your? Yes, you have.
To my other side.
Passport dilen. Passport. What is it?
5, my lord.
5 ta din tak.
I have seen. That's a finding, clear finding, rectification done. Millard, I have to now, Millard, whatever this decree has been rectified, stay is till 30th. I have to move the second appeal because it
stays till 30th.
30th. I'll move the second appeal, Millard, on this basis of this report.
Mr. Ghosh, now please clear me on facts. Why did you? What was the impugned order?
Millard, kindly have a look at.
Please give the facts.
Yes.
Please give the outline facts. What happened?
Millard, if your lordship takes the impugned order, which was passed by Millard, the executing court, wherein the executing court said, Millard, there's a non-compliance of the order passed by the Honorable High Court at Calcutta.
That is for reconstruction.
That's for reconstruction.
No, please give me the facts.
Yes, initially, Millard, there was a suit for declaration of injunction, wherein Millard filed by Millard, the decree holder,
opposite party, yes.
opposite party, wherein Millard, a prayer was there that the opposite party is a permanent employee of ECL, the teachers. Millard,
what is the decree path?
Millard, for declaration and injunction and for inquiry into Millard, the salary he is entitled to get. On that inquiry is 7 lakhs odd is the decree, which is at page 36 of the.
That's the money decree.
The money decree on the basis of a declaration.
Yes.
You preferred an appeal.
I preferred a first appeal. I lost the first.
Yes.
First appeal dismissed. Thereafter, you preferred a second appeal.
Second appeal preferred. The grounds in the second appeal was Millard in this type
So
of cases.
second appeal could not be proceeded because there is a defect in the.
There's a defect in the decree.
Yes.
So Millard, it was sent back to the court bill. Millard, records were not traceable because of the division of.
They have put the decree into execution.
Yes, they have put the decree in the execution. Now, Millard, I came to revisional court, wherein Justice Sarkar was of the view that pay cost of rupees 1 lakh, which I've already paid to him, and reconstruct the report and secure 10 lakhs. That I have done. But Millard, time frame was given. Within that time frame, that was not done because the records were not traceable. Thereafter, I came to court, filed an application. My reconstruction file is ready as I shown to your lordship.
Where is the order of the, please take me to the decree first.
Yes, kindly have a look at the decree which is at page type copy. Type copy take down page 36. Kindly have a look at page 36 of your lordship's brief, Millard. Page 36.
If it is it 25?
Yes.
Yes. Kindly take the type copy. It's very illegible, Millard. So I
Page?
said, kindly take Millard page 36. Page 35, 35, 36.
No, where is the, to get a declaration mandatory recurring
Yes,
grant?
36.
No, where is that amount? It's a 7 lakhs
Millard,
and all.
it has to be, I have to carry on this on the basis of the declaration to pay the recurring plaintiff to get a
Oh,
decree
that
of
is, you have
mandatory-
computed that amount.
Yes, I have computed. And Millard, it's Millard 7 lakhs something, Millard. 24,000 and odd.
All right. So there is no dispute with regard to that.
No, there is no dispute. What is the decree? That
All
is
right.
the decree.
Ashunto,
And I've deposited 10 lakhs.
all right.
Millard.
Please let me. This
And it's
happens.
also, the matter is also there's an advantage. If someone, my lord, has done, my lord, this type of matter, he knows, my lord, what directions to be passed.
After all, it could have has been
So
disposed
what
of.
was
It's
not done for 10 years, it has been done, my lord, after 10 years. my lord.
My lord, we are extremely grateful for your lordship's interference. Otherwise, this would not have been resolved.
My lord, that's the reason I came here.
Yes, call the next matter.
My lord,
Matter number 9.
praying for expedite the hearing
Of what?
below court below. Injunction hearing.
Injunction hearing.
You
What is the suit for?
suit for declaration and injunction. A dispute is regarding the parking of a car in the same building. Both are residing in the same building.
What is the next date fixed?
Next date fixed 5th August.
5th of August.
Yes.
What happened on 19th of June?
19th of same order, my lord, adjournment sought for, and that was extended.
It's application under Article 227 of the Constitution.
Appear for the petition. Well, this is an application relating with the Order 6 Rule 17 application, which was allowed by the learned trial court. I am for the defendant petitioner. The suit for my declaration of the realization of money, 2020,
There is
of realization of money suit.
Yes.
In the year of 2020, there was a null agreement, and by which he has filed a title suit in the year of the 2015 loan agreement in 2020 after the lapse of years. Thereafter, he filed an application for order 6 rule 17, so incorporating the interest amount. The London trial court passing and no speaking order. There is some rulings they have been given. They have after that, the London trial court passed the order 6 rule 17 application.
Where is the plaint?
Kindly come to the page 12. Page 11 starts from page 11.
Where is the application for amendment?
That is when I come to page, the page 24.
24.
Page 24. Paragraph 7, he wants to incorporate.
Paragraph
7. Kindly come to page 27, 7A. That is, the wants to incorporate.
trial has commenced.
Trial as affidavit in chief was done.
Only filed.
Only filed.
This application on
Plaintiff petitioner in a suit for declaration and permanent injunction. Now, we got an ad interim order of injunction. Now, that injunction application was being violated. Now, we filed an application under section 151 of the code, before the learned trial court. Now, the only problem is, the regular learned court, is vacant. Now, the third court is in charge. My third court is very disinclined to pick up our application under 151.
It is very difficult, Mr.
But only, kindly consider, because there is a violation, we had filed a writ petition, kindly comes to page 20.
Difficult.
One day, they have even submitted
It is
the.
one day for you, but there are other matters also. I do not know the business of the charge court. Thus is very difficult.
What I was only beseeching, let the trial
Very
court.
difficult. Here also it happens, some determination is given. We cannot take the entire determination. Only exceptional.
But the scope of the suit will be frustrated. My injunction is being violated. But any one day, we shall do. They have also filed the written objection in answer to it. The 151 application is ready for hearing. But one day, let the.
When the regular presiding officer is.
There is no intimation as to when the regular presiding officer will come.
Then I can do one thing. I can give you liberty to approach the learned district judge for transfer to any other court.
Lordship, kindly does that. Kindly does that.
Plaintiff is the petitioner, my lord. Petitioner is the plaintiff in a suit for declaration and injunction, which was filed way back in the year 1986. My lord, there are several defendants. Many of the defendants entered.
What is the impugned order?
My lord, impugned order is, my lord, permitting one of the defendant to file a fresh written statement. Initially, written statement was filed way back on first
statement.
My lord, fresh written statement. I tell your lordship, just a short background.
It's a substituted heirs who have filed.
No, I tell your lordship, kindly sees the application.
What is the impugned order which was a 22nd of May? Give me a minute.
My lord.
No, previously he filed an written statement. You have challenged that. You have alleged that it is
I tell your lordship, the suit was filed in the year 1986.
Who has said that his signature was
He,
scored?
he came up with an application. He came up with an application in the year 2024, to be precise, November 2024. He says that his earlier written statement was false and he wants to file. I tell you before, my lord, the suit was posted for ex parte hearing.
There is substance in the submission of the learned advocate for the petitioner that
No, 13.
26. Plaintiff petitioner before your lordships, my lord. This is for expeditious disposal of the application for withdrawal of the suit, my lord. Order 23, my lord, rule 1(3). My lord, application for withdrawal of the suit, my lord, is pending, my lord. And my lord, after the filing of this application, my lord, the regular PO has been transferred. My lord, 2 sheet-bearer application has been preferred plus because the date fixed on 28th July, my lord.
this application under Article 227 of yes.
14, there is a caveat. Well, I don't know whether service has been affected by my.
I don't know. You are appearing. and you don't know.
I have now my junior has not yet come. That's why that's the difficulty. The order is 25th March under challenge.
Yes. What is this matter about? Section 5 rejected.
Yes.
When summons was served and when you filed the application?
Well, summons was served in 22, well, the 21st,
And 2023 you have filed
yes, my lord.
this application under
Milord,
Number 15.
Milord, in this matter, I am for the caveat, Milord. May I seek one indulgence, Milord? Actually, Milord, my client is suffering illness, Milord, at Mirzapur, UP, Milord. They are already shifted to Mirzapur. I am praying, Milord, 2 weeks at least, Milord, accommodation. There is no such urgency because review application has been rejected.
Your lordship.
So,
this is
Milord, I am
my-
praying only 2 weeks, Milord. Yesterday, I have been served. I have to
Your-
take
your
instruction,
lordship,
Milord.
If I
And,
may present my case. Thank you. Oblige, your lordship.
Only 2 weeks.
all right. Please.
As your lordship.
Yes.
Your lordship, I am decree holder and the petitioner. I had a decree in the year 2006, your lordship. And I am here from the impugn order dated 7th March 2025, your lordship. The impugn order is at the last page, your lordship, where my execution application petition was dismissed, your lordship. If I may,
What was dismissed?
my execution petition, your lordship.
Yes.
Yes.
Where is that order?
Yes, your lordship. It is the impugn order 7th March 2025. It is the certified copy, so the last 3 pages, your lordship.
Yes.
If I may just point out the relevant paragraph which might be required, your lordship. Since this court has been disposed of the matter, directing the judgment debtor to give the amount in 6 installments and
No, which page you are placing?
your lordship, the last 3 pages is the
Last 3 pages.
is the impugn order. The third last page, your lordship, 7th March 2025.
7th of March is the impugned order.
Yes, your lordship.
Which paragraph of that judge?
Your lordship, the last paragraph, since
Oh,
this
since
court,
this court, yes.
yes, your lordship, if I may, since this court has already disposed of the matter, directing the judgment debtor to give the amount in 6 installments, and the judgment debtor readily tried to comply with the order of this court by bringing check on the date fixed by this court, but the petitioner, decree holder, refused to accept the same. This court therefore has no further order to pass in the instant money execution case number so and so. Your lordship, after hearing the judgment debtor.
What was the order for which you
Yes.
sought for review?
Yes, your lordship, that is 6th December 2024 at page number 73, your lordship.
Page number 73.
Yes, your lordship. Your lordship, the third paragraph, your lordship, after ascertaining.
So for this, you file an application for review.
Review that was dismissed, your lordship, on a technical ground, your lordship. Your lordship, all I'm saying is, if I just want to show one paragraph, your lordship, of this 6th December order. After ascertaining from the learned counsel appearing for the decree holder, the principal amount that is pending to be paid by judgment debtor is so and so. That is the principal outstanding, your lordship. As was this court was apprised, judgment debtor shall pay the amount in 6 installment at rupees 45,958 only. The first of the installment will be paid so and so. Now, your lordship, if your lordship can come to the last third paragraph, where it starts from the calculated interest. The calculated interest is to be placed before this court by the learned counsel for the judgment debtor, your lordship. That has never happened before. Why the judgment debtor and how the judgment debtor can place on record the interest? And your lordship, even the decree which was passed, your lordship, in the year 2006, and the relevant page is page number 41. It very clearly states that the...
But you have not obtained the miscase number.
Your lordship, yes, your lordship.
So please approach.
If I may just point out one thing, your lordship, all I'm seeking is, I understand there was a technical ground which was rejected. I will go back, your lordship, but if it can be disposed of at the earliest, your lordship, because they have...
Next steps, you have delayed.
No, your lordship,
Yourself have
2018, your lordship,
No,
your lordship, if I may, your lordship, if I may just point out one thing, your lordship.
no direction, madam.
Just
You have yourself
point.
delayed because repeated
But-
opportunity was given to you.
But your
to
lordship,
file the number.
your lordship, if I may, your lordship,
After 12 years, they filed the execution case.
no, your lordship, that is not possible. Your lordship,
as your
just
lordship-
one
as your
thing I want to point out, just one thing, just one point for consideration. Only the principal amount cannot be outstanding, your lordship.
That is
But expedition, because your lordship, my execution petition is of 2018, your lordship.
you are not diligent, madam. This application under if such an application is filed, it just call the next matter.
Number 16.
My lord, item number 16, I am for the petitioner. My lord, there is a praying for, my lord, for direction for expeditious disposal of the matter, my lord. This is 2009 matter, my lord. One application is pending for substitution application, my lord. My lord, petitioner files written statement and there is no injunction application also.
Have you filed the revised plaint?
My lord, I am the defendant petitioner, my lord.
You have filed an application for expeditious hearing of the suit. Ashu, this application under
My lord, there was an earlier direction, my lord,
nothing.
of this
Suit
court.
is not ready. There is a dead party. One party is dead. Yes.
Item number 17, Your Lordship, Mr. Minal Kanti Ghosh is appearing for the petition has not come to court. I'm praying for 1 day accommodation, Your Lordship.
Where is he?
He has not come to court, Your Lordship.
Order 9, rule 9 allowed.
Lordship, there's
Ask him to join virtually. Where is he?
Lordship, I've just been instructed he has not come to court. I don't have knowledge where he is.
Which district he is now?
Lordship, definitely in Kolkata, but I don't know where.
Kolkata. Order 9, rule 9 allowed.
Lordship, the conduct of the party needs to be placed before your Lordship, but
Place the conduct
Lord,
of the
I'm
party.
not carrying the brief, Your Lordship.
An accommodation has been paid for on the ground.
Item number 18.
I appeal for the petitioner. Lord, my application for adducing additional evidence in my appeal has been rejected, not at the stage of hearing of the appeal, but prior to that it was taken up. So first ground is
Cannot
that
be taken up.
no, it was taken up prior to the hearing of the appeal.
Cannot be taken up.
Normal principle is that it should be taken up.
Court judgment is there. It can be taken up.
But
High Court judgment cannot be taken up in isolation. Supreme Court says it.
I have a 2022 Supreme Court which says that the stage is it should be taken up along with the appeal because court has to assess whether it is necessary for
the
purpose of the appeal. For that, you have to hear the appeal. For
The earlier
2020
Supreme Court judgment was considered in this matter. There's an earlier
previous judgment, I have not gone through the previous judgment which says it can be taken up, but this judgment, paragraph 49 Lord says, the lordship takes up paragraph 49, stage
paragraph 49.
49 Lord. কোনটা দিলে 22টা দিয়েছো তো no my lord 22টা দিলে কেন I'm sorry
There is no
I'm sorry my lord he has given this is a 2012 judgment my lord the wrong judgment কি বলছে কি দিচ্ছ না can I take up this judgment my lord that is regarding the general principles
2012-8. Which
12
paragraph?
Paragraph 49 lordship kindly takes my lord
There is substance in the argument of Mr. Banerjee, learned advocate for the petitioner, that that an application
Item number 19.
The applicant in an appeal under section 218 of the West Bengal Municipal Act is the petitioner before your lordship. But our application was not a representation was being made.
rejected.
Stay rejected. At the initial
What is
stage,
the order of demolition?
yes, but it's yes.
The Chatterjee, you are appearing.
But if your lordship,
5 minutes.
yes.
Mr. Mukherjee can give your lordship that 5 minutes.
Both of us. But, a complaint was being lodged by the by Mr. Chatterjee's client, my lord, that the plan has been not the revised plan has been not there was an initial plan and thereafter a revised sanction. As per him, my lord, the revised sanction was being done by misrepresentation or not suppression of material facts. So 217 was being invoked, and my lord, ultimately by the demolition order, my lord, if your lordship takes up, my lord, I have annexed. The order starts with page, my lord, 16 of my lord's brief, 1/6. Page 20 is the relevant, my lord, portion. 20, my lord, may I place before you? May I? So I'm sorry, my lord.
With the impugned order.
Yes, my lord. Kindly takes up now. My lord,
What has been done by the
this was being, my lord, this exercise was being done pursuant to the direction passed by this honorable court. May I show before your lordship that order also?
by the impugned order?
By the impugned order, on the first day, my lord, my application for stay of this in connection with the statutory appeal has been my lord, rejected. Though the court is of the opinion that if the stay order will be granted, that will not, my lord, the overriding of the High Court order that has been passed by the coordinate bench regarding representation to be considered by the authority. But since the municipality not on caveat, the court considered, since the municipality not on caveat, the court considered the presence of municipality is necessary, post it to the August.
The film for Contempt municipality?
But Contempt municipality usually, my lord, Mr. Odhikari, my lord, Nilanjan Odhikari used to appear, Contempt municipality.
He is not now appearing.
No,
Yes. He is appeared.
This matter, my lord, he also appear. In this matter also he appear.
My lord, when the writ petition was filed by Mr. Chatterjee's client.
Can I ask the junior to call Mr. Odhikari? Yes.
সোমবার দিন রাখা
আমি বলে দিচ্ছি
তো ইনস্ট্রাকশন চাইতে যাবে
Yes, Mr. Mondol. Can you inform Mr. Parthopratim Roy and Mr. Sukanta Chakraborty to come?
জজে পার্থপ্রতিম রায়কে ডেকে পাঠাচ্ছে সব করতে
Yes, yes.
জজে তো যাবে ওর কাছে
My lord, kindly consider now. My lord, I can. No, my lord.
I'm surprised your lordship is calling for Mr. Rai. Usually, my lord, people go to him.
Lord, what I am, Lord, I can give your lordship the prima facie case. Lord, even on mathematical calculation, I can show before your lordship that there is no arithmetic, Lord, the material misrepresentation. What I was having, I have applied even showing less of them. Less of that. But the municipality has come to a conclusion that yes, material misrepresentation is there because
Mr. Chatterjee, in a statutory appeal, unless this order of stay is passed, the appeal will become infracture. What
Yes, provided, my lord, he has prima facie.
implemented in the meantime.
I bow down, my lord. But the court has done nothing.
Yes.
The court, my lord, has done nothing. The court has posted it, my lord, for 30th. For hearing by within 30th, my lord, nothing is going to happen.
Mr. Chatterjee,
30th.
First is, yes, I can expedite, I can direct the hearing of the appeal. In the meantime, that order cannot be executed. If that order is executed, what remains to be decided in the appeal?
I bow down.
Because Mr. Rai has come.
I'll have to wait, my lord. Sorry.
Mr. Rai. That matter which was directed to appear as forward us today, I am told it's appearing under the heading motion. Can you come at 110. Please bring, because one or two clarifications are necessary. You have the brief with you.
Just now, I'll.
You are
Yes, yes,
send
yes.
your brief.
One
Please come at 1 1:15. Please ask Mr.
না, আমি
Kapoor
বললাম
because-
Yes, madam, I need for me, madam. I'm for the person.
Oh, you are there.
Yes, I'm there.
Please
I'm the
inform
advocate
us.
record, my lord.
Yes. Yes. Yes, Mr. Chatterjee.
No, I say, my
I
lord,
think the appeal to be heard expeditiously.
no, I am not.
Then if it is,
I can give your lordship and lord impression that it can be heard out within 1 month even. I can concede to that effect.
What I
1 month is required.
1 day is enough.
Very well, my lord.
I was trying to say, my lord, is that if he has a prima facie case, yes. But if there's an admission on the face of it, day is not
Mr. Chatterjee,
automatic.
otherwise the appeal will be coming. So what remains to be decided in the appeal
Very.
then?
My lord, if your lordship calls for the municipality, my lord, let the municipality enter appearance in the court below, my lord. And
They
30th
have not appeared.
No,
No, that's why.
that's the problem.
I'm directing them to appear.
And my lord, the
Ask Mr. Odhikari to
Yes.
come.
yes, my lord, I'm just
Appear, bring the records, whatever it is, and on the basis of that, we will let the appeal.
Yes, no.
No, no, no.
Yes, I'm passing that order.
I'm
Ask
not
Mr.
passing.
Odhikari to come.
yes, yes, my lord, I'm আমার
হ্যাঁ।
ফোনটা নিয়ে যাও আমার ফোনটা নিয়ে যাও
The problem is they have obtained and sanctioned over Millard 7.25 decimals of land. When under the under what the documents that they have said, and there is an admission on record, Millard, that I don't have more than 5.25.
no, there lies my lord the
If I accept your submission.
This is to
and
be
I
gone in.
see- And if it is,
It's
the
to
order
gone.
is implemented, nothing
Millard,
remains to
kindly
be decided.
injunct them in the meantime, Millard.
Their effect
No, no,
is amounting to
bow down.
dismissal of the appeal. This does not have any statute.
The question is, Millard, kindly directs them, Millard. In the meantime, they will not proceed with any other construction and not
construction has been complete as per their lord case.
Don't make any
No,
further
no, no,
construction.
lord, no question at all.
interest to be created.
Lord, it's my property, it's my house.
Interest
Lord,
to-
in my stay application,
Because
Mr.
then,
Chatterjee
Millard,
now will ask for injunction.
আচ্ছা আমাকে একটু বলতে যদি না দিস তাহলে সে বলে দে যে বলবো না আমি তো বলছি বলতেছে Millard, in the meantime, if they will not induct somebody else, then he will say that he was not heard, and then he will also Millard, file another application. So status quo is on today, and Millard, let the appeal be heard out on the next date fixed.
Do that, Millard. I don't have any.
And the appeal, not the stay, the appeal.
Stay has been rejected.
Stay has been rejected.
So what
This
remains
was
to be
it of
decided? Yes, I'm
Of-
passing an order of stay. I'm directing the appeal.
Appeal to be disposed of.
on the
Yes.
date fixed on 30th.
No other interrogatory application.
Nothing is there.
No, no, nothing is there.
Where is the order of the Read
14.
Court directing?
Yes, my lord.
That is
That is
11.
annexed.
11.
Page 11 of my lord's.
Pursuant to this, an order of was passed, which
Demolition,
was under
demolition.
challenge in the miscellaneous.
Yes.
Stay refused. That is the fact.
Yes.
Ashok, this, yes, Mr. Odhikari.
7th of May 2025 for hearing of the miss appeal positively. Now, my lord, on 7th of May, my lord, I was not heard, and my lord, the respondent was directed to show cause. My lord, on the 8th of July is the date fixed, my lord. Let that appeal may be heard on that date, my lord.
27 of the Constitution of India is at the instance of the, you are the defendant.
I am the defendant, my lord.
The defendant is the appellant.
Defendant is the appellant. Ad interim order, my lord.
Put up by request.
I am appealing for the petition.
Now let's call it. Yes, call the next matter. Yes.
It's an application for expeditious hearing of a matrimonial suit, Lordship, which was filed in 2017.
What is the suit for?
A divorce. Under Section 27 of the Special Marriage.
Who are you?
I am the husband petitioner, a plaintiff,
Any alimony penalty?
Lordship. That has been disposed of and paying till.
You are paying
Lordship.
this application under article. What is the stage of the matter?
Well, I beg to appeal for that. Well, this application for expeditious disposal, my lord, the preemption case under section 8, 9 of the West Bengal Land Reforms Act, and my lord, the case stage is, my lord.
Other matter accepting expeditious hearing, all expeditious hearing. What you will do?
My lord, the
Regular matters can be taken up. I think within 1 or 2 years, the regular matters will be taken up.
But my lord, this PW1 has been examined and cross-examined in part, my lord. The stage of this case, my lord.
Yes, sir. Why did not participate on 9th of August 2024?
9th of August.
Ninth of August. Resolution. You have not got 9th of August 2024 order.
My lord, resolution of the local
Yes.
local bar, my lord.
Then
My lord, one day, my lord.
Yes.
Thereafter, my lord, I regularly
so
participate.
you undertake even if there is a resolution, you will participate.
No, no.
I will direct expeditious hearing.
No, attending.
I will record that you undertake even if there is a resolution, you will participate.
No, that is, my lord.
Why?
It is not, my lord.
Why?
Expected from this learned.
Oh,
lad.
then you don't want expeditious. Then you don't want expeditious. Then the client will not suffer.
It is, my lord, unfortunate. It is, I don't know.
PO is on leave, that is also unfortunate part. On that ground, it was adjourned. POV is on leave, that is not unfortunate.
No, no, no. That is.
That is not unfortunate.
Now, if my lord, this PO is on leave, so what?
So, then why shall I direct expeditious hearing? Please tell me. What is the fault of the learned trial judge?
No, no, no.
Then
My lord,
now something.
my lord, the defendant advocate, my lord, on several, my lord, occasions, my lord, cross-examination, my lord, not been completed by making the time. My lord, kindly appreciate, my lord, this last two orders, my lord, this. The witness, namely Salam Sheikh, is present and he is examined and cross-examined in part.
It's a miscellaneous case of 2022.
My lord.
Has proceeded to the evidence stage. Then you are filing an application for expeditious hearing. And on some occasions, you did not participate. You have not annexed the entire order sheet. Even then, I find on one occasion you did not participate. There was a resolution. What is the other title suit pending?
No, my lord, only a preemption case.
Only preemption case.
My lord.
Why after order number 13, the next order is order number 51? After order number 13 is order number 51. Why?
After the March, তারপরে ও 9, 8, 13 পরে হচ্ছে. My lord, kindly give me a chance, my lord, for all orders, my lord, kindly appreciate.
For all orders.
My lord, kindly give me a chance, my lord. Evidence.
Yes, expeditious hearing. No.
For the petitioner, whether the opposite party as petitioner filed an application under section 25 of Guardians and Wards Act, my lord, in which, my lord, there was a direction for visitation of the child in the court premises.
Who are you?
I am the mother. The child is with me.
Child is with you.
Yes.
You don't want the father to
No,
meet.
I have no difficulty for visitation on the.
Then why have you challenged?
I have come up. You have kindly come to the order impugned, my lord.
Yes.
May I please, my lord? Record is put up today on prayer of the petitioner, along with the petition praying for an order to shift back the date. to an earlier date.
Which order? Oh, yes, 12th of June.
Yes.
Yes.
Another petition filed in the form of report regarding visitation dated so and so, copy served. None appears for the OP on repeated call, outside call to a so and so for hearing of the application, written objection, if any. Specific direction is given upon the IC of the PS Bardhaman requesting him to produce the minor at 12 noon or at inform the IC.
No, so minor was directed to produce before the learned trial judge.
No, the issue is not so, my lord. There was a direction in whenever I have been called before the court, I am with the minor.
All right, so Mr. Bhattacharjee, you have been directed to produce the minor. 21st of June is the date fixed.
I am ready.
So I will record your undertaking. You will produce. I will stay the. I will direct the police not to take steps, but I will record your undertaking that you will produce the.
But kindly go, because police from yesterday evening started harassing me thereafter. At 10 o'clock, the police directed me and the child to be in the police station. And thereafter.
But Mr. Bhattacharjee, I am recording your undertaking that you will produce.
I have order sheets where I can show before your lordship that each and every occasion I am with the child in the court, my lord.
The You communicate. Lawyers' communication is as good. Yes.
And the defendant in a suit for partition and for revocation of the deed of gift is a petitioner before my lord. The impugn order.
What is the order impugned?
Impugned is in volume 3, my lord, wherein the trial court had, in the midst of the hearing of the injunction application, this is the third time amendment has been sought for, and the trial court has passed an order wherein initially the amendment has to be allowed, thereafter the injunction hearing would be. I am suffering an order of injunction since 2022.
23rd June, hearing of the application for amendment has been fixed.
Yes, my lord. And
how are you agree? 23rd is
23rd for hearing of the application. This would be allowed. Thereafter, the amendment played. My lord, if my lord takes up the once the order, the first order.
Nothing. Let the amendment application be allowed. Nothing.
And the injunction.
Injunction will be considered. Voluminous application. Yes. 24.
Yes, Lord, I am for the opposite party. We are on
Who is for the petitioner?
The petition has not been.
Why are you standing behind Mr. Chatterjee?
We have not been served with a copy of it.
Right. What is this matter? Mr. Chatterjee didn't serve a copy since Mr.
Definitely.
What is the order impugned?
It's a very innocuous prayer, my lord, before your lordship.
It's an innocuous prayer, I think Mr. Kaur will not object to.
I don't think so. Lord, kindly have a look at the impugned order once.
You have annexed all the orders. What is the impugned order? I do not know. Mr. Chatterjee, why are you annexing the entire copy of the orders in two places?
This comes up, Lord, the influence of the people who belong to the appellate side, but are influenced by the original side. This happens.
Original side, a bad influence. I have not seen. It could be the influence of the appellate side.
Yes.
So,
unnecessarily, these applications are being made bulky. It's a wastage of papers.
Is basically learned from the original side. Whatever my learned senior friend says.
Yes, sir. What is the impugned order? Let us not go into that, enter into that controversy. Yes. What's the impugned order?
The second volume.
11th of June.
Yes. Kindly takes note of the IAs which have been mentioned.
11th of June.
Kindly
Yes.
have a look at. Today is fixed for hearing of IA number 13 of 2023.
On behalf of the defendant, who are you? You are the defendant. Yes.
Lord, 13 of 2023, my lord, is the application for occupational charges, which is filed along with the Order 39 Rule 1 and 2 application. Lord, gives me a second.
16th of June was fixed for hearing of that application.
I don't want that application to be heard before my application for recalling the 12A. That is to be heard first.
For recalling
12A of the commercial code. That goes to the root of the matter. The court has kept it pending. My lord, it may reject it. It may, my lord, allow it.
What is 13 of 2023?
That's the application for occupation charges, which is filed along with
Occupation charge during the pendency of the suit.
the suit. My lord, that's a very gray area now. Very gray. I tell your lordship, my lord,
Exceptional circumstances, that fact, the decision which has been passed for directing payment of occupation charges during pendency of the suit is on a extreme case.
I'll tell you a lot. There are
Now I find in almost all the suits,
There
an application has been filed for payment of occupation
are
charges
three
during the
judgments.
pendency.
There are three judgments of this honorable single bench which have allowed this. But
Following the Honorable Supreme Court judgment.
No, it's their own finding.
No, there is a
Stamp of law.
there is a decision of the Honorable Supreme Court.
Now there is a decision of the Supreme Court in 2024.
No. Previously, there is also one.
Lord, that was much earlier.
Earlier, there is also a decision.
I am not aware of that. Lord,
That's the issue now, right?
2024 was the.
All right. So now what?
Now what they are doing is in an
12A has to be heard
first.
where commercial court sector.
And I'm not even going to Lord, go into that merit at all.
With arbitration, commercial court sector. It.
Is one.
Yes.
A suit which does not contemplate any urgent interim relief. There cannot be any urgent interim relief in a suit for eviction. Shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government.
I think there is a decision holding that to be mandatory.
Mandatory.
Mr. Kaur, this application has to be heard first.
But I don't
But
know how
this-
many times this issue can be raised. Lord, there is this order 7. That's why I said, Lord, let me have a copy of the petition. There was an application under order 7 rule 11 when they specifically raised this point. That matter has traveled up to Supreme Court. In 2023, the interim order was
This was the ground.
This is one of the ground which is not placed before the Supreme Court. I'll place those judgments. And
Mr.
Lord,
Chatterjee, you give
every time, Lord, there is an order by the High Court. Lord, under clause 13 of the letters patent, when Lord, we have filed a suit for eviction. They have filed a suit, Lord, for a declaration that they are in adverse possession. Now, Lord, those two suits were filed in two different courts. There's an application, Lord, filed under clause 13. High Court entertaining that, Lord, has passed an order transferring that suit to the commercial court. Lord, both the suits are being heard together. And there is a direction that on day-to-day basis or as early as possible.
Yes, that I find 10th of June, 11th of June,
Every
repeated.
day the matter is, and Lord, the objection, then Lord, on order 7 rule 10, when order 7 rule 10 is rejected, then Lord, this application, again under order 7 rule 11. So Lord, the occupation charges, Lord, they will not allow that application to proceed. Kindly, Lord, let me prepare a list of dates. I'll come, let him serve
Chatterjee, give him a copy.
The next date fixes.
No, kindly do not grant any.
It's on Monday.
Nothing will happen. Nothing
kindly-
will happen.
No. But kindly have a look now.
Yes.
Then I have kindly have a look.
Please serve him a copy. I'm fixing.
I don't have a problem.
What is the next date fixed?
Tuesday.
All right.
Lord, they are pressing for that application to be heard out.
That cannot be disposed of in one day. Let it happen. No. All right.
But the earlier revisional court, kindly take note of para 7. Para 7.
Mr. Chatterjee, give Mr. Kaur a copy.
Yeah. Just give me a second. Lord, I will serve. There is no problem on that. There is not a cave. There was no caveat. I was not entitled to serve on him.
No. I'm not saying that. Yes. But
Now,
since he is appearing.
My lord is entertaining the revisional application. If your lordship is entertaining it, my lord, the proceeding in the trial court can't go on.
No. I am only directing.
I don't have a problem.
Yes. Please give him a copy.
Fix it on Monday as forward. No problem.
When this matter is taken up for hearing, Mr. Kaul and a senior advocate appear. Mr. Rai and Mr. Chakraborty. Yes, Mr. Rai, please. Where is Mr. Chakraborty?
Mr. Rai
Where is Mr. Chakraborty? Where is Mr. Chakraborty? Where is
Also,
Mr.
he was
Bhattacharya?
there in the morning because he.
Where is Mr. Bhattacharya? Where is he? No, Mr. Rai, only one thing. What is troubling me is you filed an application for vacating the ex parte order. What is the date when the suit was fixed for ex parte hearing?
তবে এক্সপার্টি হিয়ারিং এর ডেটটা ফিক্স করেছে আমাকে
Because Mr. Rai, please correct me if I am wrong on facts. You filed a suit. Now they filed a written, Mr. Chakraborty's client. Yes, Mr. Bhattacharya, please. Mr. Bhattacharya, what is the order by which the suit was fixed for ex parte hearing? Now the facts is, Mr. Rai, please hear me. You filed a suit. Now Mr. Bhattacharya's client filed a written statement with a counterclaim. Now you also filed a written statement to the counterclaim.
Yes.
The suit got dismissed.
My suit got dismissed.
Suit got dismissed. Thereafter, subsequently, it was pointed out that they have a counterclaim which could not be dismissed. Then the counterclaim proceeded. In the counterclaim, in that proceeding, you filed an application for vacating the. Please show me by which order the suit was fixed for ex parte hearing.
11th of 11th.
Yes, Mr. Bhattacharya, by which order the suit was fixed for ex parte hearing?
11th ওই অর্ডারটা আগে দিচ্ছিল
Mr. Rai, have you seen that order or you have not seen that order? If you have not seen that order, please take time. Please come after 2 p.m.
No.
Please come after 2 p.m. You may have to go through a series of orders.
11th of May
11th of May.
11th of May 11th of May অর্ডারটা কই আমার কাছে ছিল আমাকে বললো করার দরকার নেই আই হ্যাভ বিন ডিব্রিফড ইন দ্য মর্নিং
11th of May. Yes, please take the order. Eleventh of no, 11th of May was the money suit. They were asked to show cause why the money suit will not be dismissed. Money suit was dismissed on 12th of May.
after that
After that, show me which date. I think both of you are not ready. Please come after 2. Please consider that order. Please show me that order. For this part, none of you have pointed out this. For this, the 2 p.m. There's a division bench after that. Yes, call the 1 p.m. fixed matters.
Case number 318.
None appears for the petitioner at the time of.
Three 23, man.
Yes.
I'm for the contemners.
Yes. Anything remains? What happened?
Nothing, man. This is already.
None appears for the petitioner.
Hmm? 19 to
323
323.
Same order.
Same.
Petitioner is the same.
Petitioner is the same.
Then call the matters. Call individually.
Petitioner are the same. All are petitioners. Yes, yes.
320. Same order.
Same.
Next. Same order.
322.
Same order. Same order.
3 to 4.
No, 3 to 4 I am not. 3 to 4 I am not.
তাহলে এটাতে ওই সেম অর্ডার ওই অপোজিট পার্টি অফ দ্য alleged contempt same order,
3 to 6.
same order,
3 to 7.
same order,
3 to 8.
same order,
3 to 9.
same order,
3
same order,
to 1.
same order. Yes, call the list. Yes,
Cell number 26.
yes, Mr. Banerjee.
Custody matter. My lord, my allegation is, my lord, of international parental abduction. My lord, the baby boy has been, my lord, eloped to Canada.
Custody matter.
Custody matter.
What is the impugned order?
My lord, I wanted, my lord, physical production.
Who are you?
My lord, I am the father.
You wanted
The, my lord, baby to be produced, my lord, before the learned court, because, my lord, he has been taken, my lord, to Canada by, my lord, the mother after, my lord, a divorce, my lord, was granted by the learned court. My lord, there was an agreement prior to, my lord, on the date, my lord, the divorce was granted, that, my lord, she would, my lord, take the baby, my lord, to me, my lord, frequently on a regular basis. My lord, that agreement is also annexed. My lord, after that, my lord, a few days visitation, my lord, continued. Then, my lord, the baby was taken, my lord, the mother has remarried. Out of that, my lord, remarriage, my lord, a new child is now, my lord, born. And, my lord, my baby is, my lord, taken to Canada. I have no access, my lord, to the baby. So, my lord, this is a classic, my lord, example of, my lord, international, my lord, parental abduction, which, my lord, now, my lord, the honorable court, my lord, knows, has also, my lord, formed a committee, my lord, to look into, my lord, these aspects.
7th of September 2024 is the impugned order.
Yes, my lord. My lord, the marriage was in 2009. My lord, the baby boy was born, my lord, in 2014. 2016, mother left me, my lord, deserted me. 2018, my lord, mutual consent divorce. Baby girl, my lord, I'm sorry, baby girl. And if my lord kindly just have a, I'm sorry.
Mr. Banerjee, your evidence is completed.
My lord, I am a father, my lord, can't I?
I'm asking you,
Yes,
your
true.
evidence has
But
been
my lord knows, my
completed.
lord, how far
What
it
happened
moved.
for the evidence of the defendant's witness?
Yes.
It was fixed on 7th of December 2024.
এখন কবে আছে সেটা আগস্টে বলছিল না আগস্টে না সামটাইম ইন আগস্ট মিনিট may not be
Mother
minutes
is appearing for giving evidence in this proceeding.
yes
You have to serve. Without
definitely.
serving, Mr.
No,
Banerjee,
without serving, my lord, I cannot ask for a...
one thing, that is why it's troubling me.
Yes, my lord.
Or the other thing, I can expedite this miscellaneous case. I think that's better. That's your prayer is for custody.
True, my lord,
Your
that's
prayer is for
permanent,
custody.
permanent
Only at
custody.
the evidence, mother is scheduled to
My lord,
come.
this will
I will
continue
direct,
for...
one thing, I will direct, if possible, on day-to-day hearing to conclude that.
Then also, my lord, this would take, my lord, some time. And
Yes,
my lord,
but Mr.
and the
Banerjee,
child
the
is
next
now...
date is on when? In the court below?
My lord, sometime in the month of August, my lord, if my
Yes,
memory
so
is not, my lord, betraying me.
Serving, coming back,
My lord, I'll
orders,
serve,
and the
I'll serve in
child,
a week.
Mr. Banerjee's child is in Canada. So it's very difficult to take frequently here. First of
But
all.
I want to
Second,
see her, my lord, once. Because, my lord, now online visitation is going on. That is also, my lord, on an
online visitation is being done.
On an infrequent basis, and every time from the screen, my lord, the baby is being removed, and
So
my lord,
this
all these things have
application,
been
which
done.
was rejected by the impugned order,
Yes.
that was for directing
For
the mother
physical production, my lord.
for physical production.
Yes. And that is, my lord, covered by so many Supreme Court decisions. My lord, Supreme Court has, my lord knows, my lord has heavily come down on this, my lord,
Banerjee,
parental
I
abduction.
appreciate that, but the only difficulty is that I'm only apprehensive that whether this will get the main proceedings delayed. That's the only thing.
No, my lord,
Because
that can, my lord, parallelly
what is your, Mr. Banerjee, what is your allegation that you are regularly meeting the child through video conference, or you are having access through video
my
conferencing?
lord, that is just an eyewash.
Yes.
Just an eyewash. My lord, someone is, my lord, behind the screen, not behind the screen, my lord, beside her, whom, my lord, I can see, my lord, every now and then. My lord, continuously parroted and tutored. My lord, this kind of a visitation.
What's the period of visitation? How frequently is it?
My lord, now, my lord, it's twice. Once in a month.
Once in a month.
Once in a month, my lord, it has been reduced to, my lord, practically.
Next date, 27th October.
Next date, my lord, I'm told, my lord, just now is on 27th of October, not in August, my lord. My memory was betraying me truly. And my lord knows, my lord, once, my lord, this litigation comes to an end, then an appeal, and my lord, by that time, this child would attain majority.
Any divorce proceeding?
Yes, my lord, that is, my lord, concluded mutual consent divorce on an understanding in writing that, my lord, the baby will be with me, my lord, at least, my lord, during the holidays. My lord, kindly
There
just
is
have a
an
look at the
application which
agreement.
was disposed of.
Yes,
Where is that application which was disposed of?
yes, my lord, that application is there. Page double chart kore.
26, second application to 16.
Page 16, my lord.
16.
Yes, my lord. One. That na ota na 151 application.
Which was disposed of by the impugned order.
Page 48, my lord. That কোথায় আছে বলো না চট করে।
No, that is the affidavit in opposition.
34, I'm so sorry, my lord, 34. 1.5 page application.
34.
Yes. Agreement টা কোথায়? My lord, kindly take the trouble to have a look at page 301. Kindly take, my lord, page 30. This is, my lord, an agreement in writing signed by both of us, both the parents. My lord, kindly have a look at the date of this agreement, 1st of October 2018, on which date, my lord, the divorce was granted. Decree for
So
divorce
that
was
is by mutual consent divorce
Yes.
was granted.
And
Show me that clause of that
Correct. Kindly take, my lord, page 31, clause 2.
At that point of time, the wife was here.
Here.
Thereafter,
After this agreement, my lord, the child is allowed. Remarriage, when moved to Canada, there, my lord, she has remarriage, and my lord, baby is born now.
You want to visit to Canada?
My lord, I don't have passport. I do not have passport. Personally speaking, I do not have.
No, I'm not asking you.
My lord,
Your client.
he is agreeable. He is agreeable. My lord, he is agreeable.
You are thinking about yourself. I'm talking about your client.
Third marriage.
My lord, there is, my lord, another fact. My lord, with me, that was second marriage of, my lord, the mother. Now, my lord, she has entered into a third marriage.
And your marriage was the first one.
First and only, my lord. নেড়া বেলতলায় একবারই গেছি। তুমি কি কেভিয়েটার?
Page 35, 34.
Yes, ma'am.
By the order impugned.
Advocate, my lord, who is
In addition, that the petitioner will be at liberty. In addition, Oh, this is that matter. How much time it will take, Mr. Doctor?
Well, I have taken the time to procure the resolution and also I brought the act.
What happened?
That means choked. Now, my lord, the act postulates.
All right, come at 2 p.m. There's a division bench thereafter.
2 minutes. It will take 2 minutes. 2 minutes. Because you kindly see section 19. Then you are
Section
19 of the act.
Yes, in the name of the president.
Name of
the name, that means name.
Name of the president, act itself.
The secretary or any, that is in the name. That is the law. That is what I
Now,
say.
kindly see, I have brought one judgment. Now, kindly see paragraph 33.
No, here the fact is different, Mr.
Against the society?
No, it says even if the writ petition had been filed by the president or the secretary of the society, it would be a writ petition not by the president in their personal capacity, but for on behalf of. That is the law. No dispute on that.
No, whoever come as a secretary or president, he is the juristic person.
By name, it has to be included. By name.
But the degree will be against the society.
Yes.
But
no dispute on that.
But
by name. Statute also says so.
But this
by name.
Section 19 said so.
Yes.
Now, my lord, the
So you cannot bypass that, Mr. Dotto.
But what I am submitting, my lord,
That is right, Mr. Dotto.
whoever
This
the
section-
secretary.
No.
But it's just on that. The document we have not received the document. My learned friend is appealing for the LIC.
What document?
They said that the section 4 notice
Done.
were
Oh, yes, yes.
at LIC matter.
Yes.
So we have not received
I
any
am here for the
documents from
opposite
them.
parties.
You have not given them the documents.
I was under the impression I had to produce it before your lordship.
No, you have the copy of the documents. Please give copies to them because they have to consider that.
Lordship, it is reflected in the order itself, impugned.
Please give them the
Yes, I am
copies.
giving them. Definitely.
আসুন next matter এটা order করে দিন next ফাইলটা দিন
Matter number 28.
এটা হচ্ছে সার্ভিস হয়েছে
প্রডিউস না করে টু ফাইল করে দিন টু ফাইল দি কপিজ অফ দিস on the next step
সেশনের
Yes, call the list.
Number one,
Item number 1, I am for the petitioner.
Yes,
The rule has been issued against the alleged contemner,
yes.
and the principal allegation was the illegal construction made by the private respondents without obtaining sanction plan. Page number 28 of the contempt application, last para.
রুলটা সার্ভিস হয়েছে?
The
Please give me a minute. রুল সার্ভিস হয়েছে? Whether it has been served or not. Where is your application?
application,
Contempt application.
CPAN 9 and 12 of 2021.
9,
My application,
912.
912 of 2021, CPAN.
Pradhan is the contemner.
Pradhan is the contemner.
What was the direction passed?
Order was passed. Order dated 27.
Consider the representation.
Yeah,
To consider the representation and pass.
yes.
But no report has been submitted. The department is done. Keep it with you. But a report on report.
my lord, I am appearing on behalf of the petitioners, my lord. There was a direction, my lord, passed to exchange affidavits. Now, my lord, oppositions have been received. My lord, while we were to affirm the replies, it may not transpire that the private respondent number 7, running a proprietorship concern, has passed away. So yesterday itself, my lord, we have received a communication from the learned advocate representing respondent number 7, intimating their legal heirs.
We'll have to take steps then.
We will have to take steps, substitution.
But I appear for the respondent number 7. Respondent number 7 has filed their opposition in compliance of your lordship's order.
But now they have to take steps for.
Yes, pursuant to that, my lord, he expired. I have communicated with the death certificate.
If my lord so grants me leave, my lord, what it transfers from the communication made to us, that the sole legal heir after him stands to be one Mr. Umed Jain.
His son.
his son. If my lord grants me leave, my lord, I can make necessary incorporations in the, I can make necessary incorporation, amend the
You have to
custody
file an application.
in the course of them.
Unless you file an application, that cannot be done.
Mr. Mukhopadhyay is appearing.
Yes.
The only
I'm sorry. Lord, the legal heirs that have been indicated. Lord, we'll take up
for substitution.
We'll take.
Who has passed away?
Lord, the res- private respondent.
The respondent number 7. The learned advocate appearing for
We send it to mail, my lord. Or else we wouldn't be able to join issue.
Please sort out this. These things should not come.
Their offices are always closed at 6 Old Post Office Street.
That is
I went to serve them
Yes.
a copy of the letter.
Yes, sir. Why are you closing your office?
Complaint, my lord. It's not a complaint, my lord.
Not a
We
complaint,
send it to the
please
mail, my lord.
see
We send it to
Well,
the
we
mail.
mail
already.
it. If you provide us
Because
an
we
address, we can also mail it.
Yes,
to them.
we sent it
Alright.
to the mail already.
Reply is the point.
Grateful, my lord.
No. It's 75 na কত যেটা? Yes. এটা কিসের রেসপন্স? এটা আগে
Enter proceedings is bad. Enter proceedings is bad.
You have not made the submission, Mr. Roy.
Of the morning, my lord, I have been, now, my lord, I have gone through the entire series of records. It is my fault.
I
I
must
should
send it to your lordship. My lord, initially, my lord, my lord, truly speaking, my lord,
If you have made this
no,
submission.
my lord, I didn't make this submission only because of the fact, lordship kindly sees their, my lord, application and prayer. Their application and prayer.
Mostly, there are two things. You are not there. The fact remains, Mr. Rai's client filed a suit. You filed a written statement along with a counterclaim. He filed a written statement to your counterclaim. Now, his suit got dismissed. Now, thereafter, you filed an application that my counterclaim could not have been dismissed since I have an independent counterclaim that should proceed. That was proceeded. Please tell me whether any notice was served on that application or it was an ex parte application.
No, my lord, thereafter notice is served.
No, subject to question mark.
When it was
From our
restored.
end, from our end.
No. When it was restored.
No.
That notice was not.
So it was behind his back.
My lord, I tell you, lordship. My lord.
Second, thereafter show me what is the date, what is the order fixing the suit, which is the counterclaim for ex parte hearing. Show me that.
My lord, I'll show my lord the order sheets. My lord, I know your lordship's query. My lord, I would have
be only that order, not the order sheet, whereby the suit was fixed for ex parte hearing.
Yes, lordship may kindly have a look to, my lord.
The entire argument, Mr. Chakravarti and Mr. Rai, was in a different line.
My lord, I had no occasion to reply this because they have not taken this point from their application itself.
Chakravarti, you are having the entire record. This is the only point.
Yes, my lord, lordship kindly sees, my lord.
Now,
My
when I
lord,
was about to prepare, I found this. I
my
could not find anything for that.
my lord, probably I would try to, my lord, satisfy your lordship. Lordship kindly considers two things. My lord, they, my lord, filed a written statement, my lord, to our counterclaim. Lordship kindly see the date.
What is this? Who has
My lord, this is
That is the entire order sheet I have had.
enter order sheet, my lord, I have handed over. Lordship may kindly have a look to, my lord, the order sheet supplied by Melanet friend.
Yes.
Lordship kindly sees. The order dated, my lord, 19th of November 2022.
19th of November
2022, order number 13. My lord, from top, my lord, fourth line. Plaintiff files written statement to the counterclaim filed by the defendant along with statement of truth.
Yes.
Then, my lord, it was fixed for acceptance of written statement and all this. Lordship may not look into. Thereafter, lordship kindly sees order number 14, 16th of December 2022. My lord, I'll just give you, lordship, a glimpse of every order so that, my lord.
Mr. Chakravarti, I've gone through all the orders. The difficulty is that I do not have my copy. Please show me. I'm giving you the date.
Order number 21.
12th of May.
Now he has become very wise, my lord.
No.
It is my fault, my lord. It is not voice. It is our duty. That is what.
Please
Then
kindly come to the order dated 11th of May 2023. 11th of May, there were the plaintiff was, that is Mr. Rai's client was directed to file show cause. It was not filed. 12th of May, please come to the next order. That suit was dismissed. Please turn over to the next order. 16th of May. On this, you have filed a put-up petition that for fixing a date for disposing of the written statement counterclaim. Then on that, this order was passed. This was without giving them notice. Subsequently, no notice. And the basic thing is that before proceeding ex parte, there has to be an order because there has been an amendment. Earlier provision was.
I do not dispute that.
So show me that. End of the matter.
Well, lordship kindly sees.
Yes or no? Whether there is any order, yes or no, Mr.
There is no order, but I'll try to.
Mr. Chakravarti, the order 9 rule 6 says, please come to order 9 rule 6.
Mr.
Chakravarti.
Looking to because it is a settled position. I'm not.
I was only when the matter was heard, I was under the impression after hearing both the parties that this order 9 rule 7 maintainability was heard out, not on merits. I was under that impression, but
now
it is so, Mr. Chakravarti, everything after 12th of May is bad in law, nullity.
To that extent,
everything goes.
Let me argue, Millard, to that extent. If your lordship is of that view, Millard, let me argue, Millard. Millard, with regard to this, Millard, lordship kindly considers, Millard, the order sheets, Millard, one by one. Millard, I'll just take your lordship's 5 minutes time. Millard, what is their conduct? Millard, a conduct of a litigant is also.
Their conduct is very bad. Mr. Chakravarti, please take this. First, after dismissal of the suit, when your counterclaim was restored, they were entitled to a notice. They did not know. They were not supposed to appear.
Lord, I'll show the provisions.
They were not supposed to appear. Only on this day, they filed an application, I think 22nd or 20th of January. I may be wrong on the date, 20th or 22nd of January. They filed, they appeared, and then put up petition was filed on or dated 20th of
Here I am, Lord, I'll show Lord, the provisions of the Commercial Courts Act, Lord, which mandates Lord what they have to do. They have not done that.
Mr.
Lord,
Chakraborty,
assuming Lord, the suit was not proceeded ex parte, but Lord, they have Lord, the duties to perform Lord, under the Commercial
how
Courts Act.
could your application, that order could have been passed on 16 without serving them notice?
Lord, both the counter
Mr.
claims,
Chakraborty, your counter claim was also dismissed, rightly or wrongly.
wrongly, it was a mistake.
That is why, rightly or wrongly. So it was restored. They are not entitled to any hearing on that.
Lord,
I'm
Lordship,
asking you,
Lord,
are they entitled to
for
any
that,
hearing or not?
for that,
Or an
Lordship,
opportunity to be represented?
counter claim restoration application to mail করেছিলাম
Notice, it does not appear from any of the orders.
No, no, Lord. It doesn't appear, but I have copy of the emails. Lord, I have sent.
Mr. Chakraborty, order does not record so.
This is, Lordship, this is an electronic evidence. Lordship kindly takes it.
Produce that before that.
But for that, Lordship kindly sees. Lord, today, Lord, what Lord is before your Lordship? Lord, the application for simplicity, Lord, ex parte application, vacating of ex parte application that has been allowed. Lordship kindly see the scope and ambit of the application.
Mr. Chakraborty, show me the court's power to proceed ex parte without passing an order that the suit will proceed ex parte. Show me that. Order 9, Rule 6, Rule 7, there is no amendment as per the Commercial Courts Act.
Lord, even Lord,
So,
Lord, taking that court has no power.
Yes.
But Lordship, today, there is no challenge to the subsequent order which has restored the counter claim.
nullity, Mr. Chakraborty, nullity. All proceedings are nullity in the eye of law. 227 at any stage, court can look into that.
Yes, Lord, I do not dispute,
Yes,
Lord,
then-
that. Your Lordship can supply reasons.
So,
Lord, I do not dispute.
So,
Lordship, kindly see the conduct.
basically the thing is that they have to be relegated. That is the ultimate effect. All proceedings, everything goes. So they are entitled to, they may not now even show good cause also. What we are.
But Lord, Lordship, kindly visualize one thing. Lord, good, bad, indifferent, Lord, suit has been dismissed. Suit cannot be restored right now because they have not taken.
No, suit. I'm not on the suit. I'm on the counter claim.
Now, Lord, the problem.
That is also a suit.
Lord,
I'm not on Mr.
I tell you, Lordship, is the
suit.
problem.
Only, no. That cannot be restored.
Lord, I tell you, Lordship, the problem. Now the problem is, Lord, now although Lord, that point will not be sustainable in the eye of law, Lord, they have filed 2 Lord, interlocutory applications thereafter. After one, Lord, they are saying, Lord, the entire Lord, agreement has an arbitration clause, and Lord, it has to be relegated to the arbitrator for reference. Section 8, 5 and 8 application and production of original. That is not sustainable because in their written statement.
I'm not deciding that, Mr. Chakraborty. I'm only, the issue is they filed an application because the order was also that. The impugned order was also that, because I read the impugned order, I could not find. But when I thought that what is the date I should see, because I was trying to go through those provisions and the orders, so I could not find. That is why I requested both of you. I could have passed, because if I have missed something, that was what I was thinking, because you have handed up the entire order.
I'll show you 2-3 provisions.
If you have missed something, for that I have requested both of you to appear.
I'll show your Lordship 2-3 provisions of the Code of Civil Procedure and Commercial Code. Whether his conduct is at all justifiable or not, Lordship, can you see?
Not justified, Mr. Chakraborty. I'm accepting.
Even the court. Even the court.
Yes, whether, my question to you is whether the court could have proceeded without serving him a notice.
Lordship, kindly have a look to the provision under Order 8, Rule 6A. This is the fundamental provision of counterclaim. How the court functions and what are the procedures, Lordship, is written. May I just, I will take your Lordship to subsection 4, but before that, may I just read, Order 8, Rule 6A. A defendant in a suit may, in addition to his right.
No, what is the point which you are trying to argue?
The point is, sum and substance of this provision is, counterclaim should be treated as a cross suit.
Yes, no dispute.
Cross suit.
Yes.
Now, Milord CPC, Milord, so as the Code of Civil Procedure is silent about Milord the procedure to be filed, procedure to be followed in a counter claim, which is going on analogously with the suit. Milord, there is no, I could said Milord 6A and 6D. She kindly sees, Milord, the rigors of Milord the suit, whether it should be followed in toto in a counterclaim.
It's a suit. It's a plain.
Milord, I can give you an example. Milord, there are judgments which says, Milord, in respect of our Milord, then Milord, everything goes. Milord, there are judgments, Milord, two sets of judgments are there, Milord, where Milord, court has held, Milord, in respect of counterclaim in a commercial suit. Milord, whether the section 12A Milord, rigors has to be followed or not. Some Milord courts are saying, Milord,
Mr. Chakraborty,
is a mandate, it has to be followed.
So, I'm not on that. All points, all objections you can raise at any point of time. I'm not on that. Only thing is that whether the suit could have proceeded ex parte.
Yes, Milord,
at that stage could have proceeded without passing an order recording that the suit shall proceed ex
Milord,
parte.
for that, Milord, I was trying to show, Milord, the regularities, Milord, which are to be followed in a suit, whether, Milord, it is at all, Milord, mandatory. Milord, on the part,
According to you, this is not
Milord,
to be
the
followed.
Civil procedure is not, Milord, so far as Milord 6A is concerned, Lordship kindly sees, Milord, that's why, Milord, I was just trying to ask.
Yes.
Lordship kindly sees, Milord, Order 8 Rule 6A. Milord, subsection 2, Lordship kindly sees, because subsection 1 is not relevant.
Whose copy is this?
This is my
copy. Take it.
Milord, my copy is with your Lordship. Huh?
Yes, your copy is
marked.
I've marked that. I've marked.
Milord, I knew, Milord, your Lordship might have, Milord. Milord, Milord, that's why, Milord, I produced all the certified copies.
No.
All the copies.
That's better, Mr. Chakraborty. You have done that because though I have gone through all the orders, but I was still then I've kept it for your assistance because I may have missed some of
Milord, your Lordship has rightly pointed out. Milord, I didn't find any Milord speaking order, Milord, fixing the counterclaim for Milord ex parte. That is there, but Milord, whether
counterclaim is a suit. It is to be proceeded with.
It is a cross suit, Milord, it is written.
Yes,
cross suit.
Mr. Chakraborty, cross suit. What is the difference between a suit and the cross suit?
Milord, the Code of Civil Procedure has never defined that.
So
Milord, it has, Milord,
Mr. Chakraborty says it's a plaint, it's a suit. So decrees also pass, separate decrees to be passed. What more? And Justice Tandon and myself in a division bench has passed an order that it is also to be separately registered.
Yes. No
so
doubt.
separate number is to be also governed.
She can see whether it is separately registered or not. The same Milord has been registered.
Mr. Chakraborty, yes. But in spite of direction, that's the procedural irregularity. You are not registering, but that does not say that it's not a separate suit. It's a suit. And if it is not, Mr. Chakraborty, your counterclaim could not have been restored. This based on that, on merely by that, it could not have been restored.
The provision
that submission
that no, I'm not.
Because then the order all the proceedings is bad. It could not have been restored.
Order 8 Rule 6D is very clear.
Into that.
Lordship, kindly see 6D for a moment.
Yes. Even if the suit is dismissed, counterclaim will proceed. That is why I'm saying. So counterclaim, how it will proceed? It will proceed as a suit. Rightly, that is why if you make this submission that it is the same thing, then it could not have been restored. For
Milord,
that, I was...
three things, Milord, I'll just submit. Milord, here, Milord, in respect of the counterclaim, Milord, the proceeding, if Milord, the Code of Civil Procedure applies, Milord, then Milord, the defendant has to, Milord, I have to, Milord, cross the Milord hurdle of showing, Milord, someone has been served on defendant. Milord, here what happened? Milord, Milord, since they were appearing in the suit,
service of summons is not required because they have filed written statement. That is why I told you. Prior to dismissal, they have filed the written statement. So summons was served, whether served, not served.
That amendment of the Code of Civil Procedure.
Yes.
This is a hurdle, Milord, I have to cross. Service of summons. Milord, initially what happened? They were
Mr. Chakraborty, we need not go that far.
Milord, my Milord, basic purpose was to show, Milord, all along, Milord, it was not, Milord, all the rigors of Milord, a suit was not following. Milord, the code was, Milord, counterclaim as a cross suit, which was, Milord, going on analogously with the suit. Now, my lord, what happened, my lord, on that particular day, if your lordship kindly sees, my lord, from the day, my lord, when the injunction was posted for hearing, from that date onwards, my lord, 3 consecutive days, they didn't appear. My lord, they didn't appear. My lord, the suit initially was fixed for.
Show me an order which states after your counterclaim, firstly, no notice was served when your counterclaim was restored. Secondly, after restoration, show me that notice was served, court's finding on that. I will not look to your email. Please show me the court's recording. That notice was served upon them. In spite of that, they did not.
There is no order, my lord.
Then order 9 rule 6 sub rule B.
Mr. Chakraborty, end of the matter.
Sub rule
There
A.
is No,
Your
nothing.
lordship kindly considers, visualize for a moment, not the entire cost of the learned commissioner, whom Lord
Mr.
recorded my deposition.
Mr. Chakraborty, I'm not going into that. Evidence,
Milord, what is Milord Milord, may I just ask this question to myself? Milord, what is the conduct?
evidence,
1 and 8 months,
Mr.
Milord, there
Chakraborty,
remains.
evidence will remain. Evidence may not go, but he will have a right to cross-examine. That,
Milord, that I object. Milord, why? Milord,
Mr. Chakraborty, all proceedings goes
Lordship kindly,
90.
Lordship kindly consider.
IFSC,
Milord, I have a
please show me-
judgment.
Mr.
Milord,
Chakraborty,
even-
there are 2 things. Please show me 2 orders that they were given notice prior to restoration, then
Milord, I cannot.
Then-
But Lordship kindly considers one thing. Milord, even in case of Order 9 Rule 7, Milord, I have come up with a judgment. Milord, in case of Order 9 Rule 7 is allowed.
I will not go to Order 9 Rule 7. I am on Order 9 Rule 6.
6 sub rule A.
6.
Sub rule A.
Unless you cross 6, no 7 comes.
Order 9 rule 6 sub rule A.
You have pointed out Order 9 Rule 6 on the last occasion.
Lordship kindly.
Placed heavy reliance on Order 9 Rule 6.
Because
on last
their
No. Yes.
their
rightly, I am
application
not
is
saying-
based on that.
Yes. So please cross Order 9 Rule 6. Then I will come to. There's no necessity because that is why I'm telling you. There's no necessity to go to Order 9 Rule 7 at this stage. It's an infructuous application they have filed. It's an infructuous order that has been passed. All proceeding goes. It was not necessary on the part of Mr. Rai's side to file Order 9 Rule 7.
Milord, Order 8 Rule 6 Lordship
Mr.
kindly.
Rai's counterpart has also not checked the records. They have filed application. You have also made arguments. You have not raised any point and an order was passed.
Milord, the moment Milord
7 was not, I will hold it was not maintainable at that stage.
But Lordship kindly sees Order 8 Rule 6A for a moment.
Will-
Milord, my satisfaction.
That part of your submission, Order 9 Rule 7 was not necessary. It was an infructuous application. To that, I can accept.
Milord,
your
the
submission.
judgments are all in line with the Milord precedents, Milord, that Milord, the defendant cannot be relegated to a stage which is more harmful, Milord, to Milord what it could be
If in Order 9 Rule 7,
in case of Order 9 Rule 7.
that stage has not come. Because Order 9 Rule 6, there was no order ex parte. If his suit is posted for ex parte hearing, then after that, for relegating Order 9 Rule 7, could not have proceeded ex parte. There is no order recording that the suit is proceeding ex parte.
Lordship may kindly have a look to Order 8 Rule 6 for a moment. No, I understand.
Rule 6A.
6A.
Yes.
Milord, subsection 2, Lordship kindly sees. Milord, just to show Milord, it is a cross suit.
Order 8, yes, Mr. Chakraborty, there is no dispute. I am not disputing that.
Again,
It's a
Milord,
cross
Lordship
suit.
kindly sees sub rule 4.
Yes, counterclaim shall be treated as a plaint and governed by the rules applicable to plaints.
Plaints.
Yes. It's against you, Mr. Chakraborty.
But with regard to Milord, the written statement, Milord, Lordship kindly sees only one provision. Thereafter, Lordship kindly sees 6B. Where any defendant seeks to rely upon any ground as supporting a right of counterclaim, he shall in his written statement
Kindly
state.
come to 6G. Written statement also that rules will apply. What are you saying, Mr. Chakraborty?
Yes, written statement also.
Plaint rules, written statement rules as provided in the code, all procedures will apply. What are you saying? Issues are also framed on the counterclaim. Issues are not framed.
Issues not framed.
Have to be framed on the counterclaim. Nothing has been done and we have proceeded to the argument stage. How could you?
Now, Milord, if your Lordship kindly comes back, Milord, to the Milord order, Milord, which restores Milord the suit, restores the counterclaim. Lordship
Yes.
kindly
Which restores the counterclaim, yes.
দাদা বসো বসো, তুমি তো জিতছো, বসো
তুই বললি আমাকে,
বসো
তুই আমাকে বললি, আমি একটু বলবো।
বসো।
Mr. Rai has not been briefed today. He is not briefed today. So you can make your arguments. He has confessed that he has not been briefed today.
No, I can supply.
Yes.
Add Millard, I.
21.
The 16th of May order.
Millard, just
That
16th of May.
16th of May and
16th of May is the order restoring.
yes.
yes, Millard, just before that.
I know the dates by heart now. I know.
It is my fault, my lord. It is, I've gone through the.
11th of May show cause. 12th of May dismissal. 16th of May restored.
Lordship, can you take
20th of January he filed an application. He appeared on 22nd of June. All the dates have been
now,
recorded
Lordship,
here.
the
And I
considers, Millard, the suit and the counterclaim was running anonymously.
has to be. Mr.
So, Millard, there is no requirement. Millard, there is no requirement for passing a separate order in respect of counterclaim.
Mr. Chakraborty, once it is dismissed, now after it is restored, so a date of hearing is to be passed. What does Order 9 Rule 6 say? When a suit is
But Millard, in case of
hearing,
yes,
so it's a hearing. When the hearing starts,
but in case of analogous
hearing starts
Millard, hearing starts, Millard, immediately thereafter.
immediately. What thereafter? From when?
Framing of issues.
Show me the framing of issues.
Millard, to that
Show me the
extent,
framing of issues.
to that extent, Millard, may I just humbly submit, Millard, both the Millard counterclaim and suit were running analogously.
Mr.
So, Millard, there was
Chakraborty,
no occasion.
Mr. Chakraborty, if there is no framing of issues at whatever point of time, before, after, counterclaim hearing date could not have been fixed. Could not have been fixed. And there was no occasion on the part of the court to proceed ex parte also.
But Millard, in cases where Millard, the cause of action is Millard partially same, Millard, there need not be Millard separate issue Millard to be framed, subject to Millard correction.
Issues have to be framed because it's a counter suit. You are making a counter claim. Why written statement is directed to be filed? There was no necessity there. When a written statement is filed, some material proposition of fact and law asserted by you has been denied by him. That's an issue. That is not to be framed. What are you saying?
But Millard, all the rigors of Millard, the Code of Civil Procedure, Millard, in respect of a suit, need not be followed in respect of counterclaim.
Then, Mr. Chakraborty, your counterclaim could not have been proceeded once the suit has been dismissed. Once for all, it has gone.
No, Millard, since he has filed a written statement, as Millard, in it
Dismissed.
happens.
If your counterclaim is a suit, plain, dismissed along with his suit, end of the matter. If you are to restore it, Order 9, Rule 9, because your suit was also dismissed. Have you filed Order 9, Rule 9? No. Could not have been.
I filed an application.
Order 9, Rule 9, miscellaneous.
In the nature.
To have been registered as a miscellaneous case.
Service.
Notice has to be served.
Served.
Nothing. Then it goes. If you are trying to make that submission, your restoration also goes. If you are going to that extent. I have not gone to that extent.
Lordship, kindly, Millard, see, Millard, what is the impact? Millard, Millard, submitted my written notes of argument.
These 2 points, I only wanted this.
Millard, they allowed it to, Millard, proceed.
I know their conduct is very bad, but the proper procedure was not followed.
Then, Lordship, kindly, Millard, my humble submission, Lordship, kindly, Millard, compensate my client so that, Millard.
What compensate?
Millard, the entire, Millard,
Nullity.
entire, Millard, commissioner's cost is huge. Millard,
Mr. Chakraborty, what did you do? You took that risk. So proceeding is nullity. Who will compensate? Why he will compensate? Proceeding is nullity.
Millard, it is also a duty on his, Millard, to communicate.
Show me that you have served him notice. You was put on notice by the court.
Yes, Millard, by court I have not, but
Then-
Millard, through email. Millard, the chief was served. Millard, the copy of the
Mr.
disposition was served.
Chakraborty, in a civil revision application, there is no caveat. You serve a copy upon the other side, and the opposite party does not appear.
Your Lordship may
Then-
ignore.
Then
Problem
is that the question you
this is a settled law, Millard. I cannot dispute that. But Millard, Lordship, kindly
there is no
see,
recording.
Millard, the problem is, Millard,
Mr. Chakraborty, whatever you may say, he had knowledge. He was sitting in the fence. He was watching everything accepted, but the court, nothing from the records. You have to show from the records.
Miller, on the
I
part,
the emails and other
no, on the
things.
part, Miller, basically, Miller, it is a fault, Miller, on the part of the court. But Miller, the litigant, how suffers lordship can you see? This is a
So-
classic example.
Pray for,
Miller,
so pray for compensation from the appropriate authority. Person. So if some issues are there, because,
Except from my notice, my lord, I must be grateful to your lordship.
thank you.
It's my fault, my lord. I should have.
No. This happens with the,
Gone to the application and the order, improved order.
but it was helpful since Mr. Chakraborty has given the entire bunch.
Today I have asked you to
Miller,
supplement.
I thought, Miller, it should be handed over because,
no.
Miller, they have not taken this point. But
Really, Mr. Chakraborty, that really helped me. Because I was only, you have given the entire bunch, I was trying to find out that orders. I could not find out.
Miller, now, Miller, the matter is over. Miller, the first day, Miller, the client came to my office. Miller, I, Miller, didn't, Miller, make myself, Miller, understand, Miller, how, Miller, it is, Miller, going on without, Miller, fixing.
Yes,
But, Miller,
call
they have
the-
not.
Thank you. Yes, call the next matter.
Monthly list, the ones you want.
This matter was mentioned citing urgency.
Your Lordship, I am for the petitioner. The petitioner are the joint property owners and they filed a
What
title.
is the order impugned?
Your Lordship, I'm praying this application for expeditious petition. Expeditious proceeding of the matter, Your Lordship. Petitioner filed a title suit.
Order 7 Rule 11 has been disposed of.
No, Your Lordship, that has
When
been
it is
pending.
fixed. Injunction application has been disposed of.
No, Your Lordship.
When the dates are fixed.
Your Lordship, till 2024, it has been pending.
What is
Order
the next date fixed?
Next date fixed on, Your Lordship, 20,
This application under Article
21,
This
25 to
Has been served thereafter on the medical ground, my lord, he has not filed the within period of time, so it has been rejected.
Right.
1 month, my lord, the rent is due, the April 2022.
Maybe.
That is, my lord, the only count, and he has annexed the copy
When the
of
summons was served, when you filed the application.
my lord, summons
Please
was-
give me 2 dates.
That is, my lord, page 20. Page 20, my lord, 15/12/2022, he filed the application. And my lord, the notice has been accepted on 5th September of 2022.
No, you summons was served on
5th
15th
September 2022.
and you filed this application on
15/12/2022.
15/12.
Kindly see the top.
Yes, appeared. This application under Article 227 of the Constitution of India All right. একটা করে দিন
For the petition, my lord.
Yes.
My lord, in a suit for partition, my lord, I'm the defendant, one of the defendant. My lord, my application, my lord, under section 151, my lord, for construction, my lord, in spite of a status quo, my lord, that has been rejected. My lord, citing, my lord, 3 grounds, all of which, my lord, are bad. My lord, firstly, my lord, it has taken, my lord, that I have not placed any undertaking, that in case, my lord, it is found that, my lord, I have made construction more than my share, my lord, that would be demolished. My lord, my undertaking is there. The other 2 grounds is, my lord, that no sanction plan is, I've not produced a sanction plan. Sanction plan I produced as Firisti, my lord, I've annexed the entire Firisti. And my lord, thirdly, my lord, I've not put mentioned about the cost, that is also there. My lord, kindly takes up my application, my lord, I've prayed for, my lord, construction to be made under supervision or of the commissioner, my lord. Now, the matter was, my lord, admitted.
Was admitted?
Admitted. My lord, my lord, there was a direction, my lord, to serve.
Who is appearing?
My lord,
Have you notified them prior to mentioning for upgradation?
that has not been, my lord.
Then why are you mentioning for upgradation without serving? How do they know when this matter is taken up? This matter was mentioned citing urgency, considering continue.
That
I'm
filing the affidavit.
Urgency it was upgraded, but you have not given notice. Yes, call the next matter.
Item number 1379.
You have not served. That is the minimum that is expected.
Milord, my suit, Milord, kindly stay, Milord.
Nothing.
Stay the proceedings.
Yes. Yes,
Milord,
Mr.
I was
Banerjee.
saying it was my suit, Milord.
Mr. Haradon Banerjee. Yes, it's your matter which has been called on.
Lord, I could not follow because he is arguing.
Yes.
That is the reason. Lord, in terms of your lordship's earlier order, Lord, dated 28/4/2020.
Yes, Mr. Banerjee, have you served notice of upgradation upon the other side?
Lord, practically no appearance. For 2 days, no appearance.
Maybe.
Then I
Nothing
am praying
on
for
the opposite
adjournment. I am praying for adjournment.
No.
No, let it be fixed, my Lord.
Not
I
if you
am
revert
praying
back,
for
Mr.
adjournment.
Banerjee, I am following this practice unless you have served notice for upgradation, it will revert back to its original. All matters. The earlier matter also.
Lord, 2 times, my Lord, we have. Your Lordship recorded it.
Banerjee, you will appreciate you are a regular practitioner. A matter is appearing way down in item number 1379 in the combined list. You are mentioning without notice for upgradation. How will the other side
Nobody
know?
is appearing, my Lord.
To
2
then serve
times
upon
we
the
have
opposite
given.
party because Mr.
I
Banerjee.
register post with AD again.
Yes.
Again.
Whatever it might be.
Therefore, my Lord, let it be done.
No.
Lordship fix it. I can give a notice.
This matter was mentioned citing urgency.
After giving notice, this
that.
much may be given.
Then liberty is always there. No liberty is necessary for mentioning come on any Wednesday, you see the crowd. I'm relying on that. I'm asking everyone to hand over the slip and see this is the plate. You are sitting here from 2 p.m. None of the matters notice was served. I'm not checking up the notice. I'm relying on the learned advocate submission. None of the matters notice has been mentioned.
Lord, practically we are of the
And
thinking. We are thinking.
I'm telling you, I'm spending 1 hour on these mentioning slips.
Because, my Lord, we do not know.
All the matters you will be finding dates have been fixed on successive dates. And this
Lord,
is the
because
result.
the interim order till June.
But Mr. Banerjee, this is the result. The minimum that is expected for upgradation is you have to serve notice. That is not being done. None of the matters. Pure wastage of time. Only it's called on 2-line order, revert back to its original. Other matters could have been taken up.
Therefore, liberty, my Lord, liberty may be given upon.
Liberty is always there. Yes, call the next matter.
Item number 1399.
This matter was mentioned citing urgency. First of all, however, consider
In this matter.
Lordship, no notice was served.
This
Please
matter.
kindly take it up on Monday, Your Lordship.
same order, revert back to its original position. Yes,
Let it be on Monday, Your Lordship.
No.
Yes, since he has.
No. You have not served notice. Same treatment. No Article 14 violation. Yes, next.
I shall serve and come back.
You do that, whatever you want. Yes, next.
Item number 1484.
Yes, my yesterday your Lordship was kind.
Yes, you can move that. Yes.
Can take up. My
Yes. What do you want?
Unfortunate degree holder is before your Lordship whose application for this execution application has been rejected on the ground that I have not asked for permanent injunction in the degree, and secondly, the construction which has been made by the illegal construction which has been made by the judgment debtor, in that construction, the feature of construction has not been mentioned. And
Where is the decree? Where is the decree?
My Lordship, decree is at page 20, at page 26. Page 26.
Yes.
It starts from 23, the relevant portion as 29. Sorry, I beg your pardon. 20. Ordering portion at 20. And then initially they suit for 15.
Yes, permanently restrained from interfering and disturbing. Now, Show me your tabular statement, execution application.
Execution application is what you find at page 34. Relevant paragraph, paragraph 5, 6, and 7.
No. This is 34 is the miscellaneous case. Show me the tabular statement. The execution application.
I have the execution.
Where is that?
Page 40. It starts from page 40. Relevant.
40.
Yes.
40 is not the tabular statement, sir. This is order 39 rule 7.
34. Starts from 34. Relevant portion.
This is not the tabular statement, sir.
That's the execution application.
This is not the execution application. Tabular statement. Where is that? Where is that?
Not annexed. Perhaps it's not annexed. But that is not annexed.
No, you want mandatory injunction now to demolish the illegal unauthorized. That cannot be done. There was no decree for that.
But that is one of lots of kind.
No, it's a decree is only permanent injunction. No mandatory injunction. No demolition of structure.
Subsequently, this structure hasn't been.
That is,
Subsequently, I was all along in position. Lots of kindly have a look at my plate. What was the suit for? Lots of kindly come to page 50. 10 and relevant portion at page 7, paragraph 7.
sir, whether the executing court can go behind the decree.
That is
So only the decree is to be executed. It's not the decree. You have not obtained the decree for mandatory injunction.
I was lawful owner of the property.
Maybe.
I have the porcha. I all along in possession.
Maybe.
My apprehension was against the defendant that they may grab my property illegally by demolishing the boundary wall. That is my plain mallet. That was strictly.
Only the decree is to be executed. Executing court. Executing court cannot go behind that. Show me the provision that can be done by way of execution. Show me the provision. If this in violation of that permanent injunction, some construction is being made, executing court can go into that and demolish that. Show me the provision. This application under Article 227 of the.
Item number 1487.
Yes.
My lord, I have mentioned for the upgradation upon notice, my lord.
Yes,
Well, this is my lord on petition.
yes.
This is on petition, my lord, against an order of the State Commission, my lord, in the execution proceedings, where, my lord, the dispute regarding the mode of execution, my lord. Mainly, my lord, come to the, my lord, the order of the State Commission, my lord, the final order. Page 16, my lord.
Page
16. 16, my lord, the order starting, and my lord, the 19, the direction upon us, my lord, the opposite parties. The opposite party partnership constructed from the OP number 2 to 4 are jointly and separately directed to repair the defects of blistering and effervescence cracks in the wall, coming dirty water from the adjacent flat through leakage damped in the master bedroom and other room, including bathroom, and the scheduled flat, and lock the master bedroom and scheduled flat within the
So
7.
where is the order passed by the National Commission? You have prayed for withdrawal of that? Show me that order. Show me that order. Show me the order of the National Commission.
That is annexure B, my lord, page 20.
Page
20, my lord.
20.
20, yes, my lord. None appears of the respondent means the complainant over there. And my lord, we have withdrawn the application, the appeal.
Yes.
Yes, my lord. My
So
only
you have
point.
withdrawn that.
Yes, my
Comply
lord,
with the impugned order.
there is no dispute, my lord, that
To comply with the impugned order.
we are ready to, my lord, kindly come to their execution application.
No, you are
Yes.
challenging which order?
My lord, we are challenging, we applied for the commissioner because they are in the.
No, show me which order you are challenging.
My lord, that is, my lord, in the last portion, my lord, after page 67, my lord.
Page
67, my lord, the last pagination, and thereafter, my lord, the original order has been annexed, my lord. Certified copy. Appointment of the advocate commissioner, in whose presence the entire repairing work shall be done by the.
No, this was an application for recalling.
Recalling because, my lord, they have said that.
Where is this order of 18th of November 2024? Yes, where is that order?
59, my lord.
59.
Yes, my lord. My lord, my contention was that if they have not given the access to their flat, my lord, I would not be able to, my lord, complete the repairing work. They have not given, and that is their in their execution application also they have admitted that they are in the possession of the flat, my lord. Two ladies stays in the flat in questions, my lord. If they would have not given the access, how can we, my lord, without any commissioner or without anyone's presence, my lord, we cannot complete the repairing work.
Where is the order dated 8th of January 2020? Eighth of January 2020 was challenged before the National Commission.
Yes, my lord.
So you have withdrawn that.
Yes.
To comply with that. After that, how could you pray for recalling of that earlier order?
My lord, we have not.
Yes, this is an application for recalling.
This is regarding, my lord, only the.
It could have been done after you have approached the National Commission.
We have approached against the.
All right, come on Monday.
Yes, my lord.
It's a Monday 2 p.m. We
have approached against the.
Yes, serve a notice upon the landed advocate for the opposite party.
Item number 1564.
PPM today.
Daily list, item number 342.
PM2 matters were fixed. PM2 matters.
3 p.m. another matter has been fixed. 2 p.m. very bad experience.
Not even 5 minutes.
Very bad experience. From 2 p.m. I think to 10 minutes after that, from 2:10 to I think 2:45. All matters, upgraded matters, in none of the matters notice of upgradation was mentioned, given.
Mine is too expeditious disposal will be finished in 2 minutes. For that, he will come.
Yes, yes. Yes, Mr. Mitro. You have concluded. Yes.
On the last occasion, your lordship may kindly peruse my lord's order. Your lordship has posed a question to me, my lord, whether, my lord, a point of non-joinder of a necessary party, my lord, can be, my lord, raised for the first time in a 227 application. In the context of that, my lord, the East Bengal club is, my lord, who has been really affected. But the injunction has been passed against Mr. Mitro's client, the IFA. So, my lord, whether non-joining, my lord, East Bengal club makes my suit fatal or
Take
not.
me to the plane because I've forgotten everything. Please take me to the plane.
Lordship.
The prayers, I think, if I look at the prayers, then
But they have challenged
page,
order passed by the first appellate court.
plane.
The plane starts at 143.
143.
143. And prayers at page 152.
চ্যাম্পিয়ন করছে
অন রেকর্ডই থাকবে রে
আমি নিয়ে গিয়ে
Oh, yes. Now I recall. Mr. Mukherjee, yes, because your primary relief claim is against the club because the primary relief is for declaration that scheduled match should be declared as cancelled. And in aid of that prayer, you have sought for injunction. Yes. So whether this main prayer can be granted in the absence of that club.
Lordship. That number, your lordship will also see, apart from that, Lord, that is one of them, Lord, the prayers.
But that is the primary prayer, Mr. Mukherjee. All are consequential.
No, Lord, so far as
Aid
Lord,
of that.
your lordship will kindly consider who can declare, Lord, a
If I can
match.
put it in a different way.
Lordship.
If this prayer is held to be not maintainable, whether you are entitled to any further reliefs, any
Very well.
interlocutory reliefs.
I'll try to answer, my lord. The my lord, kindly consider whom Lord declares whether, my lord, a match is going through or the points are allocated or whether a match is cancelled.
That Mr. Mitro's client.
Mr. Mitro's client. So they have been arraigned as a party, no doubt about it. Now, my lord, they have been restrained, my lord, from declaring, my lord, the East Bengal club for the time being till, my lord, the injunction application is heard out, my lord, as, my lord, a winner. So, my lord, the question here is that in the event that there is a non-joinder of a necessary party, but without an objection being taken by either of the parties who say about the affectation, whether, my lord, the suit can be, my lord, rejected at the threshold or not. This is that is what is falling from your lordship. To which, my lord, my answer will be, my lord, no, because it is a curable defect. Now, my lord, if there is a non-joinder, but it can, my lord, at a point of time, my lord, if you lordship.
Curable defect means there is a defect. As on that day, yet to be cured.
Lordship.
If you say it's a curable defect,
Lordship.
then you admit that there is a defect,
But I
is curable, but till now not cured.
Well, I do not say that it is a defect per se. It will become a defect once, my lord, a party to the litigation takes an objection. So, my lord, as of today, this being a, my lord, an order which is arising out of an ex parte ad interim stage, none of the parties have appeared. In spite of, my lord, the objection, they have not, my lord, filed a written objection to take the point about, my lord, that non-implementation of a necessary party. Now, my lord, that cannot be considered for the first time in a 227 application, my lord, in my respectful submission. Because, my lord, first of all, my lord, if at all there is a defect of parties, if somebody takes a point about the defect of parties, my lord, that can be cured. One. That does not, my lord, ipso facto, my lord, can be stated to be, my lord, that the plaintiff is to be rejected at the threshold. Now, my lord, if the plaint can be, my lord, maintained, even without, my lord, one of the necessary parties, for the sake of argument, I say so. Therefore, my lord, the injunction order which has been passed not by the appeal court, my lord, in the ad interim stage, on the ground that my lord, it can be my lord, set aside on the only on the ground of non-impletement, but in my respectful submission, but that should not be the case here. So, my lord, yes, even my lord, there should be an opportunity granted, and this point has to be taken by a party that you have not impleted a necessary party to maintain a suit. Now, my lord, coming back my lord, to the nature of my lord, the injunction order, your lordship will kindly see my lord, the injunction order.
This contention, are you willing to place reliance upon any provisions?
But
of the Code of
I
Civil
have come up
Procedure?
with two well-established judgment. Your lordship knows about the powers under 227. In one of the judgment, my lord, where before the Supreme Court, in the question arose, my lord, whether my lord, a non-impletement of a necessary party will my lord, debar a person a relief. The Supreme Court said that even at this stage, before this court, such person can be added. Now, my lord, when this matter fell from your lordship, we advised, my lord, both of us, our client, that for abundant caution, file an application for addition of East Bengal Club as a party. So, my lord, that application is already on record. So, my lord, this is my lord, yes, I'll put this before the district judge. So, my lord, অনেক আগেই করা উচিত ছিল বলেছিল বাট অ্যাপিল কোর্টে করেছে ইট উইল পার্কুলেট so as of today Lord, that East Bengal Club not being impleted, Lord, that point of it
Has it been allowed, Mr.
no, Lord, it has been filed
So if
today.
not
It has been
allowed,
filed.
you cannot
No, no,
say that the defect has been cured.
no, Lord, at least an
And
attempt to
because-
cure.
yeah.
Attempt to cure.
Attempt to cure is there.
Yes.
It's not cured.
Uh,
And you must be saying in that application that such and such club is a necessary party. Must be in
I have
the
not checked.
must be in the application. That is the only agreement. Otherwise, cannot be accepted. That has to be. That one line has to be there in that application. Otherwise,
application
not that. So we take it that there is no application as on date. Show me, please show me. Yes, yes, Mr. Mukherjee.
Now, Lord, if your lordship kindly comes to the impugned order, which is under challenge, Lord, by the impugned order, Lord, the honorable, the learned court, Lord, says
Certified copy or the page number nowadays.
Lord,
Many matters are being filed without the certified copy. Here it's the certified copy or the.
Lord, the order dated 19th of February 2025, order number 2.
Yes, 19th of February.
With the operative portion, the next page, the rest.
The appellate court's order.
Appellate court's order. Lord, that is the subject matter
Yes,
of
yes.
them. The respondents are hereby restrained from declaring and announcing East Bengal Football Club as champion of the Premier Division of Calcutta Football League, such and such, till such and such. So, Lord, the restraint order basically is on the IFA.
But concerning
Lord, the East Bengal Football Club.
Mr.
East Bengal
Mukherjee, the
Football
right-
Club doesn't come before your lordship, Lord, to say that we are affected. It is not espoused by only the IFA.
They are not aware of these proceedings.
No, Lord, if this
They are
order
not
is
aware of
there,
these proceedings.
if order is there, Lord,
No, order is, Mr.
from
Mukherjee,
February.
two parties, they were not aware of this.
So, Lord,
But if by some order, certain parties' rights are affected.
Lord, in fact, Lord, the parties' rights are not affected. Their rights are, Lord, only kept in deference. It is not affected finally.
Not finally,
Kindly
but at
see.
the interim stage.
It is only, Lord, I must say it is deferred. If it was not decided, I would have understood what fell from your
An
lordship.
order of injunction can be passed against a
But
non-party.
it was, Lord, up to 19th of March. Now that
Against
it
a
has been
non-party.
extended.
Against a non-party, affecting rights of some non-party by way of an order of injunction.
In fact, Lord, we were alleging, Lord, that but I'll come back, Lord. I have got instruction about, Lord, the text of, Lord, the application. It is that we have not said, Lord, that they are a necessary party, but we have said that they are, Lord, Their presence is necessary, my lord, for proper
Proper party.
adjudication. Yeah, proper party.
Proper party. Yes, yes, that is proper party.
Exactly.
Proper party, non-impeding may not rise to dismissal of the suit.
Lordship.
Distinction between the
Lordship.
non-joinder of a necessary party and a proper party.
Lordship. Now, my lord, so far as, my lord, our contention in the plaint case was, my lord, that we made an application, we gave a repeated letters. He's saying, Mr. Nag. And your lordship said that they do not know about the order. My lord, your lordship
Sab
sees
is
that
now
copy.
having notice of that. Yes.
Now, my lord, we have repeatedly, my lord, your lordship has seen the letters that we have asked for, my lord, for the rescheduling of, my lord. The basis of passing this order was, my lord, that we also gave a letter, which, my lord, the IFS said is under consideration. Now, my lord, it was said that those are, my lord, in the court below. And, my lord, that was, my lord, the reason why the learned judge said that since you are considering our prayer, therefore there will be an interim order for a, my lord, a particular period. Now, my lord, as of today, on my instruction, my lord, the IFS has not come up with, my lord, their answer to my lord, the prayers. That has been kept hanging. They have not yet not filed any written objection in spite of direction either before the trial court nor before, my lord, the first appellate court.
Injunction application, written objection not filed.
Not filed. Not filed as of today. So, my lord, at this juncture, when they do not come forward to file their, my lord, a response to my application, either contending about, my lord, the non-joinder of a necessary party, or, my lord, they do not respond to, my lord, the order passed by the court for filing, my lord, the written objection. At this stage, my lord, after, my lord, the passing of the interim order, which I have enjoyed for, my lord, about more than 3 months, but it should not be vacated, my lord. That's my respectful prayer before your lordship. Now, my lord, now, my lord, your lordship will kindly, my lord, see, my lord, the injunction order, my lord, that I have, my lord, injunction prayer, that is at page 165.
Appellate court.
My lord, before the appellate court, before the trial court, it was same.
Prayer is the same. Prayer
is same. Another point, Lord, yes, Mr. Chatterjee says that in the event, Lord, there is a replay, and IFA decides on that, but the point table that I have, it is in all likelihood, Lord, my club will be, Lord, the champion.
No, if
there is a, Lord, these 2 matches are replayed.
226, Mr. Mukherjee could have been done. Not in 227.
No, 227, I know, Lord, the scope is very limited, Lord. I am just not, Lord, taking your lordship to this, but on a side note, Lord, we are just. So, Lord, this was, Lord, the entire scope of the matter, that till you decide, kindly do not declare somebody.
So your simple prayer was that I have made a request to you for postponing or rescheduling a particular match, and no decision on such representation has been taken. So till that
you
time
have
you take a
assured.
decision.
Yes.
So do not declare the result. That is the injunction which you have paid for. Yes.
And it is also in the rules, Lord, that they will have to take a decision on, Lord, what I have applied before them, at least for reconsider. Either they may accept or they may not accept. But they have to take a decision on that point.
So according to you, no decision on your prayer was made.
Your Lordship has seen this letter, my Lord, that on 18th of February, my Lord, that.
No, this is not part of this petition.
This was, my Lord, I am.
What before that?
So, Mr. Mukherjee, if this was not part of the appeal
Yes.
court of the trial court,
No, I'm not, on instruction, I say, I have not verified. Before the first appeal court, this was not filed and shown before the first appellate court, and this was the consideration for passing the interim order.
have you given a copy to Mr.
Where
Mitra?
on the last occasion he was given.
It's not reflected in the order.
No, it might not have, but not coming back to the question whether it was relied upon by the trial court or the first appeal court. But my answer to
So
that
there are
is
two things, whether it was part of the record.
No.
There are two things, consideration may not be. There, consideration of some documents may not have been done, even though it was part of the record.
No, it's not
First
part
thing
of
is
the-
that whether it was part of the records. Because Mr. Mukherjee, on instruction, submits that it was part of the record. There should
before
not
the appeal court, not before the trial
Yes,
court.
before the appeal court.
Submission is, my lord, as I have heard, that, my lord, it was shown, my lord, it was not even filed. Possibly there is no fiduciary even, my lord, filing it. Now, my lord, I was not there. I mean, my client was not there. But, my lord, the record, the appeal court order does not, my lord, if this is the basis of the order, my lord, would have, my lord.
Oh, this was an ex parte order.
Ex parte order.
So you are not there.
No, no.
Yes.
Trial court
No,
refused
that's
by an elaborate order, and my lord, appeal court, my lord, your lordship has seen, my lord, passes an one-liner.
Yes, yes, Mr. Mukherjee.
Now, my lord, the first page of the
But
imperial order.
Mr. Mukherjee, you have to only showing will not do whether it was part of the record.
But I'll
Because
just
Mr.
try
Mitra
to.
may not be knowing because he was not present.
I'll just try to assist from the text of the impugned order. From the text of the impugned order, I'll just read it for your lordship. Peruse the application for temporary injunction, which has been supported by an affidavit and documents annexed herewith. 1. On perusal of the materials and copy of documents on record, and after learned advocate for the appellant prima facie, it appears that the appellant has not been provided with the appropriate opportunity to play the game as per law, which may cause irreparable loss and injury, and fundamental right to participate in the match. And moreover, it is also prima facie appears that in spite of intimating the matter to the authorities, no reply has yet been given in support of the same. This necessarily means, Lord, that I have.
No, what you are trying to submit from this?
Lord, the page, Lord, the second
18th
page of the-
according to you, 18th of February, this was supposed to be, a decision was supposed to be taken.
Lord.
Meeting was.
On 18th, Lord, the document that I handed over is, Lord, I made a prayer on 17th. They gave me this letter on 18th. I moved the injunction on 19th.
Trial court order 17.
Trial court is prior to that.
No, trial court is prior to that.
Yes.
I am talking about the first appeal court.
Yes.
Before the first appeal court, this document dated 18th of February was relied upon. Before the first appeal court. Why I say this? Because the text of
Injunction, additive, Mr. Mukherjee, it's expected what the documents were before the trial court, that will be only considered before the appeal
But
court.
this was a subsequent event, Lord. I did not suppress because this came to me, Lord, the day before, after passing of the trial court's order. So
Show
I
me
thought-
your pleading with regard to this, this document. Mr. Mukherjee, even if you rely upon some documents, pleadings has to be there.
Lord,
Without that, you cannot.
I'll
Merely by producing some documents, show me that you have made these pleadings, because in the appeal court you have made some pleadings. So according to you, this is a subsequent event. You could have stated that this is a subsequent event. After that, I have got this. Show me the pleading with regard to this.
But I'll just, Lord, I will. Oh, Dr. Barkar, just talk on. But in the meantime, if you're
They may check up, you can proceed. Yes.
But in the meantime, Lord, why I say that, Lord, this was considered because, Lord, the order, the second page of the order.
Yes.
Of the first appeal court.
Yes.
Your Lordship will kindly see.
Second page, yes.
Moreover, the second line, it also prima facie appears that in spite of intimating the matter to the authorities, no reply has yet been given in support of the same. The non-reply indicates refusal for getting an opportunity of being heard to the grievance or problem whatsoever. So, Lord, the learned judge was not referring to, Lord, this particular letter which was relied upon. So this was, Lord, before the court,
this does not show, from this, it cannot be said that this was relied upon. Mr. Mukherjee, let us take an hypothetical case.
Lordship.
You may say, look, I've made a representation, but no reply has been given. And it's ad interim on the basis of your documents. You have said, you must have said, look, I have pleaded that I have made this representation, no reply. Court may have proceeded on this basis. Because if this was there, court would have recorded, yes, it prima facie appears that at the time of filing of the suit, no decision was there because this is the letter of 18th, it was fixed for hearing. This is a very important document for the purpose of this ought to have been referred. Prima facie, it's only on the basis of your submission that I have made a representation, no reply has been given, as simple as that. Because if that is so, this is a very important document. This ought to have find place in the impugned order.
I'll just not take instruction. I'll take instruction whether it was filed by way of a firisti or not before the first appellate court. In the trial court, this document was not there.
This is a subsequent document.
I can certainly.
Yes. Yes.
Not denying, but they say that they will be taking a decision on that date is wrong to discuss letter received from Diamond Harbour Football Club on
which date is wrong?
The letter should be read at number 1.
Yes.
That date should be 17 instead of 18.
Oh, the date of the letter?
Yes. My club's letter.
Oh, 17 they have received.
17. The letter is dated 17th.
No, but they say date of receiving.
They might have received, I can check.
Agenda says letter received.
Lordship.
It might be your letter is dated 17th but received on.
Maybe.
Yes.
That is also a possibility. Yes.
Yes.
Then, Lord, to consider the point table of CFL First Division. And in the item number 1, and consideration of Premier Division League point table. That is what I am concerned about. So, Lord, the first point, if I confine your Lordship, Lord, that says that the agenda is will be this. And this is called for on 20th February.
Mr. Mukherjee, please show me your letter dated 17th of February once.
My lord.
Please show me your letter dated 17th of February. This is the difficulty because this long gap.
Lord,
It's not there on record.
This letter is not on record. No, 17th of February, which was the subject matter of consideration.
17th February টা আমাদের এখানে ওটা আগের দিনকে দিয়েছিল কিন্তু in record your lordship speak
but you have given, but was it part of the records? Show me from that page.
আরে 17th এর ওই চিঠিটা
No, Mr. Mitra says that this letter is not there.
It's not. নিয়েছিল যদি কোর্টের রেকর্ড আনায় দেখতে পাবেন বাইরে রিপোর্ট যদি আনায় কোর্ট থেকে
এখন ঢুকে যাবে ও আমরা সবাই জানি
But Mr. Mitra, are you disputing this?
No, I really did not try to, because 17th February or whatever it is.
Yes. Have you seen this? Have you seen this? Are you disputing this? Because something is that a meeting was called for considering a letter received.
Suit was filed before that. So their right crystallized before this letter.
No, that is a different
And
thing.
I showed your lordship, my lord, when I made my submissions that their case was, or their case, only case,
Yes.
that matches on consecutive days without giving a
That you
date.
have shown that the subsequent match was
Yes.
cancelled or rescheduled, whatever.
The intermediate match was, my lord, cancelled or postponed.
Rescheduled.
There, my lord, I submitted before your lordship that their case goes.
No, I follow that, but what is your
17th February letter is not, I found it out. It is part of record.
17th February? Where is that?
Page 150, not 100.
Misstatement there.
109.
109.
109.
Prachi Sports Venture, not Diamond Harbor.
This is Sachi Sports. Yes, yes. Yes, Mr. Mukherjee, this is a different thing altogether. It's not your letter. Is it that letter which is being?
Cannot be. It speaks about letter of.
No,
Diamond
not,
Harbor.
this is not my Diamond Harbor Club's letter. This is
this
not
is
a
not-
Panchi says about not the, they are not sponsoring this.
So
They
this is,
say that frequent rescheduling will affect them, not the business.
this
lot.
is not that letter.
No, not, that is not.
So this might be a different thing which was agenda was there.
No, the agenda was all through not about the dish.
Where is that letter then? 17th of February. This is not that letter.
But that is not annexed, Lord, I am told. But not they acknowledge that not they received a letter from Diamond Harbor Football Club.
But did you file that along with your documents? Because it's Mr. Mitro who has filed this revision application. He must have annexed only those which were served upon him. So is it your case that some documents which were served upon him has not been included? That's a different thing. You are having your copy. You can check from your copy whether that letter was part of that.
But,
Because unless Mr. Mukherjee, these are part of the records, court cannot look.
I understand, Lord. I understand, Lord. My Lord.
Say yes, those were part of my records, but the petitioner has not included that. That's a different thing altogether.
But it might be, Lord, the 141, the letter appearing at page
141.
141. Lord, it looks like, Lord.
Yes, it's 17th of February.
This is the next the next page. Bapi page is 141.
142.
141 and from 142.
141 and 142. Yes, Mr. Mitro, this is that letter.
Must be, but I cannot make any comment. It's
এটা আমি খুঁজে পাচ্ছিলাম না তখন এটা yes, it was annexed as annexure G
To the plate.
to the plaint.
Annexure G or H?
It was annexure G.
G. An injunction application H.
H.
Because you have annexed the plaint to the injunction application, no? Why one annexure difference? Might be you have annexed the plaint.
there might be.
Yes, Mr. Mukherjee, please don't hear Mr.
I just only saw the
extraneous things don't hear, which are relevant.
So, Lord, this letter, Lord, this is not what that they have not said that we will be considering on 20th of February. As of today, before your Lordship.
আমরা বলছি পরের সোমবার উইক
রথ পেরোলে
রথ পেরি
Yes.
জ্বর সেরে যাবে।
Yes.
Now, my lord, after they have received and they say that I will be considering on the this particular letter, as of today, they have not come up with any, my lord, reply to this. No written objection. Therefore, my lord, they should not be, my lord, given with that opportunity to have this injunction order vacated and defeat my right. So, my lord, they should, my lord,
When you file the suit,
but I, no, আমি the suit 16 তারিখে file করেছি 16 তারিখ
no,
16 তারিখে
suit when it was filed.
17 তারিখে move
16 ফাইল হয়েছে 17 মুভ হয়েছে।
yes filed on 16th first
Suit.
injunction was moved suit
On
February.
17th, on 17th.
17th refused. We got this letter, we moved this on 19th,
So that was refused.
refused.
So
Appeal
they
filed.
so they did not have any notice of the suit at that point of time.
No.
So thereafter you moved the appeal,
Yes.
and appeal
19th.
order was passed on 19th. 19th injunction was passed.
Up to 19th of March.
Yes. So they could not have taken a decision once it has come to the notice that suit has been filed.
There was no injunction not to take any decision.
There was not, your lordship will kindly have a look at not the
Injunction was passed. How could they take a
Injunction was-
decision thereafter?
restaurant for declaring and announcing.
Yes.
And here they are supposed to, Lord.
Mr. Mukherjee, when your prayer in the letter dated 17th of February,
Yes.
they could not have considered after your filing of the suit. When you have communicated the order of injunction, there will be violating. Let us suppose, hypothetically,
That would amount to, my lord, allowing the suit.
they consider, take a decision and reject your prayer. Then you will be coming up and say, you are rejecting my prayer. This will be violation of that.
But I'll just try to, Lord, no, Lord, what they say is, Lord,
Decision নিন 7 দিনের মধ্যে করবে। তাই যদি হয় ডিসিশন নিন।
so let them take a decision, Lord. They have
After hearing-
said that, Lord, they have called for a meeting, Lord. Let
Not-
them
Mr. Mukherjee, not 226.
not,
226.
because they, Lord, called for a meeting. They had an
No,
agenda.
I cannot go. I have to scrutinize
Lord.
only with the scope of that.
Very well. But as of today, but even if I
If
go
Mr.
by, Lord, the
Mitra says, yes, let me take a decision, I will take a decision. That's the other way round. But now I cannot go beyond this.
very well. No, Lord,
Both of you have made a representation. Mr. Mitra says, all right, I will consider, I will take a decision. That's a different thing altogether. Otherwise, cannot go to that.
Monday,
I cannot direct them, please consider that and take a decision.
very well. Lord, I will just not try to, Lord, apprise your lordship, Lord, that the learned judge in the first appeal court not only said that you do not declare a particular club, but there was no, Lord, injunction restraining them to hold in terms of, Lord, their agenda in the meeting.
So according
Lord-
to this, there was no restraint order on taking
Holding
a
meeting.
decision.
Or a holding meeting. So they were free to, Lord, take a decision on the agenda that they had published because there was no direct injunction restraining them to hold a meeting.
Mr. Mukherjee, have you seen the agenda?
Yes.
Consideration of the Premier Division League point
Yes.
table to consider the point table. Let us
Yes.
assume in considering them, they declare. Cannot happen.
No,
So how the
It
how a
was not
decision-
only the point table, Lord, has to be decided.
what remains thereafter, Mr. Mukherjee?
Lord,
if
there
the
has to be
point-
declaration.
point table is finalized because this after the match, after the league, if the point table is decided,
Lord,
what remains after that? The person who has got the highest number of points.
After the
It's
point
only
is,
a
Lord,
formality. Declaration of the champion is only a formality.
under the rules, Lord, there is a scope of objection even after the points are allocated. Lord, I can take your lordship to the rules. But Lord, only consideration of the point table does not, Lord, necessarily mean always that, Lord, the person who is given the highest point may be declared as a champion. It is subject to objection by, Lord, the clubs who have participated in, Lord, the particular league.
When the final timetable will be considered after everything is done, not at the intermediate stage.
Timetable,
Final-
points table.
Points table. Not the timetable, points table. Final time, points table.
After the matches are over,
After
all the matches are.
all the matches are over. So it has to be the ultimate thing. Maybe under the rules, you have a right to raise an objection. But it's the ultimate finding, taking all decisions. They may arrive at a finding, yes, this is the final time point table. You may object on that. But the when the point table is finalized, it's prima facie who is the winner, runners up, and all that.
But
you may have a right to object. That's a different thing altogether. Formally, it may not have been.
Lord, the consideration of Lord this point table. Suppose Lord a point has been given to a particular club wrongly, or Lord somebody objects that you should not have granted this. So there has to be Lord an overruling or Lord considering that objection. After considering that objection, Lord the points might alter. So Lord a particular club who has been given X point might get X minus 1 or X plus 1. So, Lord, at that stage, Lord, it doesn't decide about the fate of a particular club against which, Lord, the injunction order has been granted. So that was a stage, yes, that was a stage, Lord, it was a stage of not pre-final consideration. I mean to say, before the final consideration, this is at the pre-stage.
Of the winner.
Yes.
Prior to a stage prior to declaration of the winner.
Yes. So, Lord, that was, Lord, that was not affected by the injunction order. All that the injunction order for the particular time being said was that you do not declare a particular club to be a champion of such and such. So Lord, that does not stand in their way, Lord, for holding the meeting. In the meeting, what they are supposed to do was not consider my Lord the letter which I have just shown before your Lordship at page 141, 142. They have said so in their agenda that I'll be considering your letter to discuss letter received from Diamond Harbour Football Club on such and such and consideration of Premier Division League point table. There are two Lord agendas in item number 1. I'm not concerned about the other one.
1 and 2 is only relevant.
2 is also not a CFL. I'm not concerned.
Oh, CFL is a different.
I'm not concerned.
Yes. Only 1.
1 has got 2 elements.
Yes, one is with regard to your prayer,
and the consideration of the
other
point.
thing is with regard to the.
So, this has also not been done. Therefore, they cannot take the point that pursuant to the order of the ex parte injunction, I could not hold a meeting.
Any other point you want to?
Not okay.
Want to cite any decision?
But the decisions are not. May I come back on Monday? I'm under tremendous pressure to make this submission before your Lordship.
Don't hear that. Mr. Mukherjee, I'm not against fixing. Only difficulty is that the other matters cannot be taken up. So other fixed matters are also there. Mr. Chatterjee is also having another fixed matter. So that is the, not for today, but in the next week. That's the only difficulty. That is why I'm requesting both of you in these fixed matters, if it can spill over, if you can continue. How much time you will take?
But I'll be just relying on not the judgments. I tell your Lordship, not in the in view of my Lord's last date's order, not about not the 227 and whether not that point. Not I have come up with 2 or 3 judgments not on that point. Now, not so far as not the merit of not the matter is concerned, I have already covered before your Lordship.
So cite those decisions.
Now, Lord, another Lord, if your Lordship kindly considers page 93 for once about Lord the rules which require Lord a consideration.
93.
93.
But none of the courts have considered these rules.
Lord, it is yet to be considered because Lord.
I'm sorry, my lord.
The single court, the trial court, my lord, had called upon, it's recorded in the order that I repeatedly called upon them to produce the rules and the rules were not produced by them. That's recorded in the order. They cannot rely on this now. I have annexed it, yes. I did not rely on any of those documents. Kindly come to kindly come to my lord, page 1.
So, did the appellate court consider these rules?
No, no,
Then Mr.
no, it was not. But all that I not mean to say that with reference to page 93, if your lordship
Yes,
is not
93,
convinced
yes,
about,
yes.
I can produce law at any stage of the proceeding.
but any team not intending to play a match shall make an application in writing to the secretary at his
Anything not,
state house.
any team not intending.
Yes, that's me.
13.3.
Lordship, 93, yes, yes, 13.3, yes.
Yes.
So, Lord, there are rules, Lord, which govern, Lord, my letter, which requires, Lord, a consideration by the IF.
I won't consider it a final order, but you have to consider.
Yes. Yes.
Judgment.
Yes, Mr. Mukherjee. Yes. Yes, yes. 93, 13.3 you have referred.
Lord,
Yes, what is the
so,
next?
Lord, this is a Lord, why I say that Lord, they are obliged to do so in the context of my 17th February letter, which they have given, Lord, that we will consider in the meeting in not done so. Now, Lord, whether Lord, the East Bengal Club is a necessary party or not, Lord, on that I have already addressed your Lordship. First of all, Lord, East Bengal Club doesn't come forward to say that I am affected. Secondly, Lord, there was no written objection filed by my learned friend's client accepting the civil division before your Lordship. Where also, Lord, I do not find that, Lord, their point about the non-impletement of a necessary party has been taken as a ground. Secondly, Lord, this non-implement of a necessary party, if at all, is a curable defect. It doesn't go to, Lord, the filing of the suit, and the suit cannot be rejected, Lord, and consequently, Lord, the injunctions cannot be granted. That cannot be the case here.
Yes.
The point about, Lord, the non-implement of a necessary party was, Lord, a point taken, Lord, from the your Lordship has, Lord, asked me this question. It was not even their point, Lord, in the civil division application. Now, Lord, I'll be referring to, Lord, about, Lord, the scope of 227, Lord. These are all well settled. Your Lordship knows, Lord, 2009 Volume 5 Supreme Court cases 616 at paragraph 31.
Yes.
এটা হলো 2009 Volume 5 SCC 616 para 31 226 227 রিলেটিভ স্কোপের ওপর এর লেটেস্ট অনেকগুলো জাজমেন্ট এর উপর চলে এসেছে
I think I have to follow this decision very strictly.
No, but it is only for this particular matter. There will be certain judgment cited.
It has to be followed.
Only for a particular matter.
That might be in some way reducing something.
I know. But if your Lordship goes, your Lordship has much experience. If your Lordship goes by the text of certain judgments, not 99% of the 227 applications are liable to be rejected.
That is why I'm saying I have to follow now from today. I have to follow this. strictly. Yes.
Lord, these are
So
not,
paragraph
again, that's the
31,
reason I
that is
said,
what
Lord,
we spoke.
that these are.
Yes.
And Lord, 2012
No,
volume
sir, because you can cite, that was only a,
but these are all well known to your lordship, Lord.
what is the next decision?
2012 volume 8 SCC 706, Lord, paragraph 26 and 27. This is not concerning whether, Lord, it can be added. A necessary party, Lord, can be added at a later stage of the proceeding or not.
Show me that. Which paragraph?
12 8 SCC 706.
Paragraph?
Paragraph 26, 27. Lord, your lordship may start reading from paragraph 24 to understand, Lord, the context of it. 24 টাও লিখুন। কেউ দিয়েছিস?
দেখি ভুলে গেছে ও paragraph 26, 27.
Lord, from paragraph 24, if your lordship starts, Lord, your lordship will understand, Lord, why the ratio has been.
Yes.
আমি তো Christ Church of ওই কি একটা জানো Church of Christ Charitable Trust. ওই 2000 এইটা বলতে কাজে ওটা তুই ডিসাইড করে না
Thing in reply.
আমরা রিপ্লাইটা বলবো
Firstly, my lord, I am not required to, my lord, go before the court below and, my lord, file my objection. I am before your lordship. I came up before your lordship before the time expired. I am before your lordship. My point before your lordship, I made out only one point, that, my lord, their right did not survive. The right to sue did not survive. They knew that. And that is why the day the suit was filed, a fresh letter was issued. 17th letter, your lordship will recall, my lord. Firstly, my lord, they say, the plaintiff and the petition says that on 5th of January, they made a request. Now, my lord, I have, my lord, in my petition, I have annexed the email by which the letter was sent. That was sent much subsequently, sometimes in February. They, in their petition, plain petition, do not say how it was served. But their subsequent documents, which are on record, would show that, my lord, the fixture was, my lord, published after, my lord, 5th of January.
Mr. Mittu, I think that Mr. Mukherjee accepted that there is a typographical error. It was
Oh,
Has
my
to be on February, not
the-
on January.
The case is that even long after receipt of the letter,
They took advantage of the date. They
yes,
took
yes.
advantage
No,
of.
the plain case.
Yes.
It's not a mistake. It's not a mistake, my lord. The plain case is, I give a letter on 5th of January, IFS sits tight on it, long, does nothing. Now from my lord 5th of February and my lord, the response was given my lord on 10th of February possibly. It's not a long wait. Now I say that, well, your difficulty is that you are saying that some consecutive matches on consecutive days, one match is postponed. So there was no further consecutive matches on consecutive dates. That was the case. Now, my lord, they go on issuing letters, my lord, on 17th and thereafter, my lord. That does not, my lord, I cannot go on, my lord.
That was post filing of the suit.
Post filing of the suit. And
Because the order of injunction was on 17th. So refusal.
Refusal. And my lord, kindly come to the refusal order once, my lord.
Give me 1 minute.
The trial court's order once, my lord. It's at page 31. Kindly come to page 38. I have shown this.
38.
Yes.
Yes.
It is apparent that the plaintiff has participated on alternate days on 7th September, 9th September, 11th September, 3 matches in 5 days, and then again on 30th September, 2nd October, 4th October, and 6th October, 4 matches in 7 days. It is elucidated in this court that a gap of at least 2 days between 2 matches is an ideal proposition and not a settled rule and regulation for the IFA. That apart, on being asked, the plaintiff has failed to produce rules and regulations pertaining to IFA. Reasonability is a sine qua non for any judicial order. It is also necessary to mention that the petitioner is leveling an allegation against the association that they are not providing a level playing field equally to them, even if by stretching the boundary of imagination, this court considers that the defendants are perpetuating injustice by not providing a level playing field equally and giving undue advantage to other clubs, then this court cannot give any relief to the plaintiff, as negative equality cannot be envisaged, etc. Now they do not produce the rules. Even the rules, my lord, say that they can make representation. Representation was made, and my lord, that on the basis of that, a match was, my lord, rescheduled. There was, my lord, Calcutta Football League and, my lord, Reliance. Reliance was in between. So Reliance was postponed. So their only difficulty was
That is also controlled by you. Reliance.
Must be. Yes, must be. Otherwise, I could not have done that.
Yes.
Now,
So according to you, in a way, their representation was decided in their favor.
decided in their favor.
That is the first match.
That is decided in their favor that yes, don't play matches on consecutive days. Now, my lord, this was my case, my lord, this is not answered. Today, my lord, lordship has seen, my lord, with greatest of respect, my lord, the trial court's order and well-reasoned order and the appeal court order, my lord, which deals with nothing. Nothing. Yes, balance of convenience, irreparable loss, my lord, standard words, put that and allow the appeal. That's it. Charge code. Charge code.
That is, that does not make any difference.
No.
Charge code or-
I do not say that. Now, this is the position, my lord. Now, my lord, today, my whole difficulty is, my lord, because of this, my lord, everything has been held.
That is, Mr. Mitso, you know these litigations, how long it continues. But
My lord, I was
can
told,
something not be done?
I was told, my lord, unless I can, my lord, declare the results. Now, my lord, I cannot declare the results of the Premier League.
That is why I'm asking you, can you,
If
can
I
you not
cannot-
think
I'll tell
in,
your lordship, my lord, if I cannot declare the result of the Premier League, my lord, there is, my lord, lordship possibly is aware, my lord, I am not very aware, that there is relegation and, my lord, promotion of teams. My lord, two
Yes.
teams from the, my lord,
from the lower group will come to
and from, my lord, Premier League, it would go down to first division. It cannot happen.
No. The kick now.
All right, whatever it might be, when a league or a tournament is being played, it's ideally that it has to come, results are to be declared.
Absolutely.
That is why I'm asking you. Nobody knows how long these litigations will continue. So anything can be done to resolve this, because you are much more experienced. You know
Nothing.
how long this type
Today,
of
my lord,
litigations.
only, my lord, thing is, my lord, that somehow stop it. My lord, this is the plain.
That is, Mr. Mitra, that is, yes, but how to resolve this?
Allow me to claim, Lord. We can have always at any date
How
that can
this-
fix the match, Lord. I am willing
Mr.
to pay.
Mukherjee, Mr. Mitra cannot right now here from
Let him take
here. He
instruction,
cannot
Lord.
say
I
anything.
gave him
I
He
cannot.
cannot say anything. He cannot
I
comment.
I am not very certain,
Bengal
but
has
I
to
was
have
told,
a
my lord, even
East Bengal
a fresh match cannot be done for the simple reason that, my lord, the players, my lord, the contracts, my lord, end in May, 31st of May.
It ended last 31st of
31st of May. So, my lord, the teams would change.
For my club, Lord, there's no difficulty.
That is why I'm asking you, can you take instructions on this, whether there is any possibility to resolve this in any way? This apart from the legal issues. Apart from the legal issues,
I shall take instruction.
Because
I shall take instruction again.
Because after all, it will.
Very well. Kindly keep it to be mentioned on Monday, my lord. I will, my lord, come back. But I was told, my lord, the consequences, my lord, if I cannot declare the results, I cannot declare the results of the first division.
For that I am concerned. So nobody knows how long this litigation will.
My lord, I was
continue.
told that, my lord, IFA would have to be wound up for the simple reason, my lord, for the next year there would be no, my lord, sponsors.
That is, for that I am asking you, is there any way out to resolve
Take
this?
instruction. Kindly keep it on Monday, my lord. I will take instruction. আমি কখন নাও? Kindly keep it as to be mentioned on Monday, my lord. I shall come and, my lord, whatever, my lord, the instructions.
I think they wanted this, but apart from that, I was only thinking, because after all, a tournament fate that is to be ultimately decided one way or the other has to be, because otherwise everything remains inconclusive. So whether there is any possibility, because litigations, yes, can be decided one way or the other legally, that's a different thing altogether. That's a different matter
The
legally.
suit will remain pending, my lord. They will proceed with the suit.
Yes.
They will proceed with the suit.
Yes. So what
Should be, my lord, changed. The records would be changed. That's it.
So that is
They,
why
my lord, also kindly consider the conduct of, my lord, the plaintiff, my lord, first statement 5th of January, my lord, is
that is with regard to the legal issues, not merits.
on facts.
Yes, yes.
Factual.
That I will consider. That is for the purpose of deciding this matter. I'm on
May I
the
come back
other
on-
way, if it can be.
May I come back on Monday?
I'm not recording that.
Very well.
So do you wish to file any short notes? So I can fix a date. Mr. Mitra can take a longer time to decide, because I think he also needs some time to. But no new points, Mr. Mukherjee. No new points, nothing. Only on this, if you want a short note, you can do this. When?
We'll give that.
Both of you, when?
No, Monday will be to be mentioned only for the purpose whether there should be not a replay of the matches on.
Only one day,
Lordship.
you prepare your written notes. If in the meantime, Mr. Bitso comes with a suggestion, that's a different thing altogether. No 2 dates, so you can take a longer time if you want. I know that for that, if you wanted a longer time to prepare your written notes. That is understandable. And so Mr. Mitso will also take some time because to take instructions. This decision cannot be taken in one day.
But we want to appear twice before your lordship. Once on Monday and then on Friday.
July. Yes, Mr. Mitso, when?
Can it be on 30th June, my lord?
Yes.
30th.
30th, he will not be here.
I already told my.
31st June.
Except 30th any day. 30th.
1st July. 31st. huh?
1st of July. Yes. So I'm posting it for filing of the written notes. I'm not recording it.
Lordship.
Ashwin. Heard Mr.
It is up.
He lost it. To file brief notes, not a longish one.
Well, 2 matters was fees supplemented release at 2 p.m.
There's a resolution.
I know. Well, on Monday it can be taken up. That's what I am saying.
Your lordship. Your lordship, may I be permitted to mention item number 994 of today's